Call this hearing of the Governor's Council to order. I'm going to begin by reading a letter from the Governor. Dear Councilors, I am pleased to nominate Brian K. Doxtader to the position of Associate Justice of the District Court. I submit the nomination for advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am closing the nominee's resume for your convenience. Good morning.
Good morning, thank you.
To get started, if you'd like to introduce any of the folks you've brought with you, you can go ahead and do that. Then I'll introduce the council and we can move forward with your witnesses.
Thank you, Counselor. My wife, Susan Harris, is here. My witnesses are the Honorable Justice Coffey, First Justice of the West Roxbury Division of the Boston Municipal Court, Associate Justice John Garland from the Boston Municipal Court. I have Justice Margaret Albertson from the Boston Municipal Court. And I have Representative Jay Livingstone, who was my first supervisor at the District Attorney's Office.
You didn't learn too much.
Everything I learned from him.
So like I said,
Excellent. So I just want to introduce Councilor Mardolan, Councilor Terry Kennedy, and with that, if you'd like to ask your first witness to address us, that'd be
Thank
great.
you so much. The Honorable Justice Kathleen Coffey.
This is Coffey. Thank you for being here.
Good morning.
Morning.
I am delighted. I'm honored to be here. Thank you all for your service. What you do week after week is very important. Our name is West Roxbury Court, but as I tell our jurors each morning, we're actually located in Jamaica Plain. And we represent 40% of the city of Boston. We represent the neighborhoods of Jamaica Plain, Hyde Park, Mattapan, parts of Mission Hill, West Roxbury, and Roslindale. We are a busy urban court. We have a mental health court called Recovery with Justice. We also have a pilot program addressing the needs of individuals with severe substance disorder. It's a pilot under Section 35. And we also have a homeless pool that we run out of the Pine Street Inn every month, the third Thursday of every month. I am here today because I strongly believe that Brian Doxtader is uniquely qualified to serve as a member of the judiciary. And I further believe that he will contribute significantly to the growth and the development of the craft. There are many reasons that I could share with you, but I'm going to limit myself to 4 reasons why I think Brian Doxtader is an excellent candidate. First and foremost, he is a person of impeccable character. The adjectives that I would use to describe him: he's compassionate, he's patient, he has integrity, he has courage, and he has a balanced approach towards life. Second, as indicated in his resume, is that he has the courtroom experience, not only in criminal, but also on civil matters. As a prosecutor, he was a supervisor in Middlesex County. And as a clerk, he has sat on countless small claims cases, evictions, restraining orders, mental health hearings. Because we represent 40% of the city of Boston, we end up with a lot of pro se litigants, especially on the civil side. On the criminal side, as we all know, an individual is entitled to a lawyer. But on the civil side, that is not available. So consequently, we get a significant number of individuals who are pro se litigants. As a judge, I cannot answer legal questions and give advice. So many of the litigants turn to the clerks. I have seen on many occasions Brian answering questions patiently, explaining in great detail to individuals who are confused about how to navigate their cases. He will bring this same skill set as a judge. He also understands how many good, hardworking people end up in the criminal justice system. And many times that is because other systems have failed them. The third reason that I think he will be a superior judge is his exceptional work ethic. As a court leader, it's critical that judges set the tone in a courtroom, set the tone in a courthouse. And Brian has done that as a first assistant clerk. He is in early, he stays late, but more importantly, he understands that it's just not the daily work that is critical. It's also very important to have a vision, to look at, constantly be aware of ways that we can make the court system more accessible, more accountable, more responsive to the individuals that we serve. And Brian, I'm happy to say, has been a very strong proponent of the specialty courts that I mentioned earlier, and has assisted me in the development and growth of those specialty courts. And finally, the fourth reason why I would suggest that you give him his support is a quality that I think a lot of judges struggle with. I know I do. And many lawyers struggle with. And that is the ability to listen. He is an excellent listener. He fully understands, as my father would often remind me, God gave us 2 ears, but he only gave us 1 mouth. There's a reason for that. You can learn a lot more by listening rather than talking. And that is a quality that I have seen Brian exhibit on many, many occasions. So in conclusion, I would ask for your support, and I am confident that if appointed to this position in the district court, he will serve with honor, he will serve nobly, and he will contribute. Thank you.
Thank you very much, Justice. I want to give the council a chance to see if they have any questions. Start with you, counsel.
I would just like to thank you for your work on the homeless court. And I'm sure you'll agree with me that working with the homeless and unhoused is profoundly rewarding and meaningful. And I just want to note that we have 2 homeless courts in Massachusetts, started as part of a pilot program under Governor Deval Patrick. And this many years later, we still have only 2. We work all across Massachusetts taking court-appointed cases. There are homeless people everywhere who would benefit from the homeless court. So I thank you so much for the work that you do and for bringing attention to it today.
Thank you.
Thank you. Counsel Kennedy.
Judge, I appreciate your comments. You absolutely have one of the best run courts in the Commonwealth. There's no question about that. You move cases along, you do the right thing for the people who come before the court. You have an incredibly well-run clerk's office that he's a part of. I can tell you that I don't get to your court very often, as you know, but I do occasionally. And I can tell you that for the last couple of years when I've got there, Clerk Murphy has been all over me about Brian in his application. He knows that too. So, and as I indicated this morning, Judge McDonald called me about him as well, who's been sitting in your court for some time now. So I appreciate your comments and what you do.
Thank you.
Justice, thank you so much for being here. We do appreciate your testimony.
It's an honor.
Thank you.
Thank you.
And Counselor, I have the Honorable Justice John Garland.
Welcome, Justice.
Good morning, members of the Governor's Council. Glasses. It is an honor to be here today to offer a few words about Brian Doxtader. Undoubtedly, you've seen his resume. You know that he has an outstanding education and broad experience working in our courts. What I want to tell you about is the person I've got to know over the past 4 years while serving in the West Roxbury Division of the Boston Municipal Court. Simply, Brian is exceptional. He's highly intelligent, always upbeat, and always helpful. He's always respectful of the people he works with and the people who use and need our courts. 2 examples I think that define Brian. During argument on a case in the courtroom, an attorney may cite to a recent or long-standing case. Not only is Brian listening to the argument, but in no time, he has searched for and found the case, printed it, and handed it up to me. This is routine with Brian. To an outsider, this may seem like a small matter, but to the one who must make the decision, it is indispensable. One of our most important functions as judges is to utilize jurors in the most efficient and effective manner. One thing you don't want is jurors waiting around the jury room until the early afternoon, only to be told that there'll be no jury trial that day. Fortunately, we usually avoid that problem because of Brian's leadership. He has this procedure where he'll call the assigned prosecutor and defense attorney for all trial cases scheduled that week to see if in fact they'll be ready for trial. He has an uncanny ability to weed out issues that need to be addressed by a judge. He'll recall the prosecutor the day before the trial to see if their witnesses are planning to appear. Then he briefs the judge on the morning of the trial so that if the defendant is seeking a jury trial, jurors are in the courtroom by 10 in the morning, ready to be sworn in and hear the evidence. That takes a lot of skill and perseverance and the ability to listen. And he always treats everyone with dignity and respect. That's why, in my opinion, he'll make a great judge. He works hard. He knows how to look around the corner to see what's coming his way. He cares about the law as the bedrock of a civil and orderly society, understands the roles each party must play in the courtroom, and is always offering to help in every way. My only regret about his nomination is that it's to the district court, not to the BMC, where Judges Coffey and Albertson and I sit. We'll miss him, and when I'm in the session, I'll be looking for the new Brian, but be hard-pressed to find one. That's the talent he'll bring to the bench, and that's why I wholeheartedly recommend him for your consideration.
Thank you very much. Any questions? Councilor Kennedy?
As I pointed out in the hall, you're probably the person I've known the longest who either works in the BMC or is in the judge in the BMC. And when I think about it, other than Ray today, you're probably the person I've known the longest in this building.
Is that good or bad?
So, obviously, it would mean a lot to me. I appreciate your testimony.
Thank you. Any other questions of the judge? Good to see you, Judge. It's good to see my friend, my neighbor, Judge Coffey. Thank you. And that will exhaust the folks who are speaking in support of the nominee. Is there anyone here who would like to speak in opposition to the nominee? Next, we'll hear from the nominee. Good morning.
Good morning, everyone. I'd like to begin by thanking this council and each of you councilors for the privilege of being here today. I appreciate the time you've taken for the hearing. I very much appreciated the time you've taken to have conversations with me the past few weeks. I'd like to thank Governor Healy and Lieutenant Governor Driscoll for the nomination and the show of confidence. I'd also like to thank the governor's office, Darrell Kesselheim, Paige Scott Reed, Jesse Boudou and their teams, Sonia Altamirano, Kimberly Baptiste and their teams, who have given me valuable guidance through this process. I'd also like to thank all my friends and colleagues who have been so encouraging and supportive, some of whom I believe are live streaming this hearing. And of course, I'd like to thank my family, my mother, brother, sisters, extended family, including my in-laws, who I'm sure are live streaming from their homes in New York, California, Washington, and Illinois. And my father, who has passed, but I am sure is with me here today. And to my wife, Susan, my heartfelt thanks. She is, and always has been since I've known her, my biggest supporter and champion, my very best friend. I certainly could not be here today without her. I was born Kang Jun Ho in Seoul, South Korea. As a baby, I was adopted by John and Kathleen Doxtader and raised in upstate New York as Brian Kang Doxtader. I became a naturalized citizen as a child, and in a recent conversation with my wife, I wondered what the judge who oversaw that citizenship ceremony would think if he saw me here today as a person living the very best of the American dream. I was fortunate and privileged enough to have a relatively uneventful childhood and adolescence. I was a varsity swimmer. I played drums in the marching band. I was president of the Model United Nations, which definitely made me the coolest kid in school. For college, I attended the University of Notre Dame in South Bend, Indiana. I remain to this day a huge fan of the Fighting Irish football, despite the fact that they have not won a national championship since 1988. Although I do think that this is definitely the year, which I have said every year since 1988. Following college, I attended Boston College Law School. When I enrolled, I was not 100% sure what area of law I wanted to practice. I was fortunate to participate in an internship with the Middlesex District Attorney's Office in the Somerville District Court that was both eye-opening and life-changing. What struck me the most was the commitment, empathy, and intelligence of the attorneys, victim witness advocates that I worked with. They were dedicated public servants who were serious about the law, serious about their cases, and serious about their ethical responsibilities. I was equally impressed with the court staff, the clerks, probation officers, court officers, judges, and defense bar. All of them also took their responsibilities seriously, and the defense bar was intelligent, thoughtful, and professional about their cases. I did not know going into that internship how collegiate the relationship between the district attorney's office and defense bar was, and found that to be refreshing, given what I thought I knew about the adversarial process. It turns out that attorneys can zealously advocate for witnesses in the courtroom, then shake hands and go out for a meal afterward. It was at that time that I realized I wanted to spend my career in public service, surrounded by like-minded people who had a similar dedication and passion. I've been 6 years at the Middlesex District Attorney's Office, practicing in various courts throughout the county. I was also a member of a team responsible for handling cases that arose out of the JP Lab crisis, further underscored the seriousness of public positions and the responsibility of the public trust that accompanies them. I've continued my public service career as an assistant clerk magistrate at the West Roxbury Division of the Boston Municipal Court and was named the first assistant clerk last April. I work with the public on a daily basis, helping at the counter, clerking in court sessions, hearing small claims, criminal clerks hearings, and civil motor vehicle appeals. I am again struck at the dedication and passion of my colleagues, which I find inspiring every single day. What I found most rewarding about my career in public service is the opportunity to help people during difficult times. I often think of something a boss of mine once said: we are often meeting someone at court on one of the worst days of their lives. This has been a valuable reminder of the important work that is done in the district courts and the serious impact these courts have on the communities and the lives of those they serve. I am grateful for and humbled by this nomination to the district court, and I'm especially grateful for a continued opportunity to serve those communities of the Commonwealth. I thank you for your time, and I'm happy to answer any questions.
Thank you very much. Councilor Kennedy.
I've obviously known you a long time in Middlesex. We had a number of cases together over the years. I bet you wish you gave me those quotes I asked. But the way we've had a lot of cases together. I think we did some trials together. We certainly interacted quite a bit, both Lowell, Somerville, and I think Woburn, right? The Woburn.
When I was in Superior Court, yes, yeah.
Yeah, so all of my memories are good. You were always very reasonable, always a pleasant person to deal with, always very ethical, forthcoming with discovery, always very prepared. So I think that I bring that to the table when I'm weighing your nomination. I've also had the opportunity to interact with you a lot in West Roxbury, and you've always been very accommodating to everybody, not just me. I can't see how anybody would vote against you, frankly. I think that you're a home run nomination. You've got some great support here. Judge Coffey, Judge Garland. My friend whose father was my friend hiding behind Judge Dolan. You've just got impeccable credentials, and I'll be voting for you next week.
Thank you. I really appreciate that. Thank you.
Thank you very much, Councilor DePaulo.
Thank you, Counselor. Basically what Counselor Kennedy just said, he told me when you were announced, and Counselor Iannella also told me that you come with impeccable reputation coming out of the West Roxbury Courthouse. We had a good conversation. I felt good about it based on all the things I'd heard about you ahead of time. I really like your experience and exposure to the alternative courts. And you're certainly in the right place to be getting that experience. So I'm not going to ask you any questions. I'm very confident I'll be supporting you when it's time to vote. Thank you,
Counselor.
Thank you. Counselor Civil.
Thank you. Congratulations on your nomination.
Counselor.
It was a pleasure speaking with you the other day. And I've heard great reviews from our counselor Ianella about you as well. My question for you is understanding the rule of law. How do you define the rule of law, and why do you believe it's essential in our judicial system?
Thank you for that question, Counselor. I think as Justice Garland said, the rule of law really is the bedrock principle by which we are in the judicial system. I think when we look at guidance for how cases are decided or are to be decided, we look at the statutes and we look at the case law that the appeals court or from the Supreme Judicial Court or the Supreme Court of the United States. And that's the guiding principles. It lends predictability. It allows attorneys and it allows court users to understand what the law says, why it says it, and how that guides what decisions judges are making. I have found when I am speaking to court users, a lot of times if I can show them something in a statute or I can show them something in the case law that says, this is what the law says about this, it does give them that understanding of why decisions are being made a certain way or why, even why the law says what it says, which is the cases can help highlight that this is what the law says and this is why it says it. So I think those are the bedrock principles upon which our entire judicial system and our court system is built.
So much. And my other question would be, how do you balance the due process rights of the accused with the interest of public safety and justice?
Thank you. I think you need to look at it holistically. You want to look at specifically what is the impact on this individual's life that's before you, this person who's been accused of a crime, and what are the things that we want to accomplish. District courts are community courts, and what you're looking at is how do I have a person before me who may be court involved and try to figure out how to make sure that they don't remain court involved. What are the resources and programs or the types of probation that would be appropriate for this person? And then balancing that with the protection of a particular individual or society. Is that valuable and difficult sometimes, balancing act that we're trying to do, which is we want to make sure that a defendant is given the fair chance and that they're given the resources they need to move forward. But we want to also make sure that if there's a victim, that victim is made whole and that society is protected as well. So you're always looking at it holistically, and you're always looking at all the different things that and all the different factors that go into that. When we had our conversation the other day, I mentioned if someone is incarcerated, they do return to society, and you want to make sure when they return to society, they have the resources to be able to move forward in their lives as well. So I'm always trying to think about what's the best way we can move forward and what's best for society and for an individual.
Thank you so much.
Thank you, Counselor.
Thank you. Counselor Dolan.
I agree with Counselor Zari. There's really no point in asking you very much. I was very impressed with you in our conversation and by looking at your resume, and I could see from our discussion your humanity and your character and your depth of understanding into the law. Those things will contribute to your being, an outstanding judge. But since we have the time, I want to take a little opportunity to help educate people on some of the issues that are playing out in our courts. One of them that we discussed was a relatively recent decision by the SJC, Commonwealth versus Lawn, which really, I believe, has the power to end racial profiling in Massachusetts. And I would like to see it used to do that. Yet, how old is Long? He's 3-4 years old now. The last time I checked, which was not that long ago, only 3 Long motions have been allowed. And I am very doubtful that the reason so few have been allowed is because so few have had merit. So I would like your thoughts on Long and how you will respond when defense counsel files a Long motion when you're a judge.
Thank you, Counselor. I agree with you. I think that's one of the most important cases that the Supreme Judicial Court has decided recently, because it is such a it gives a lot of valuable insight into exactly what you were talking about, which is racial profiling or racially motivated stops. There's been some expansion of it. I believe there was a case about someone walking on the street as opposed to being in a vehicle. So you can see that the courts have recognized how important it is to address those issues. I can tell you from my point of view, if any attorney brought a long motion and they met the standard, it should be allowed. I mean, the Supreme Judicial Court has spoken and said, this is what the law says. So as long as that standard is met by any attorney, I certainly think the law there.
I've heard anecdotally, I don't know who did this, but I've heard of long motions not even being permitted to have hearings. I trust that you would, of course, have a hearing on a long motion.
I'm surprised to hear that. I think that it's the type of, again, it's a Supreme Judicial Court case. I believe any motion brought under that merits at least a hearing and a conversation to determine whether or not the attorneys met the standard at the very least.
Thank you, thank you. And I wanted to ask you about your work on the JP Drug Lab case. We had talked about this, that my view is that it was a terrible shattering of public trust. And I appreciated your understanding that and the efforts that you took in order to restore the public trust. I think extraordinary work by the SJC as well. Can you just talk about that?
I think the words you use are exactly right. The shattering of the public trust. When I was at the district attorney's office, I was on a team that addressed those issues at the district court. And so any motion that an attorney brought in regards to a case in which the JP Lab or Annie Dukin specifically had been involved, we took a close look at those. I spent countless hours looking at these cases, and what really struck me, really underscored this whole thing, is that the number of lives that were affected by this, the number of people who were falsely accused of crimes who should never have been in the justice system because the results were tainted, the defense attorneys, the prosecutors. I, as a prosecutor, and I've never met a prosecutor who says differently, I have zero interest in prosecuting a case where someone's not guilty. So I never, to this day, understood what the motivation would have been for some of the things that happened at that lab. We were all public servants trying to do the ethical right thing, and that was the complete opposite of that. It really underscored to me the need for everyone who worked in a position of public trust to act ethically, act responsibly, and to, in these instances, really act neutrally. The lab should have been acting neutrally and just giving what the results were, and they did not do that. So for me, working through those cases, and we filed countless null process, we dismissed countless cases, but in a lot of these instances, the damage was already done. And so that's something I think about, to this day, I think about all the time, and I would keep in mind if I were fortunate enough to be appointed to the bench.
Before I ask you the last question, I just want to let you know that Councillor Ionel is a huge supporter of yours, and that meant a lot to me. Also, Councillor Kennedy, of course, Councillor Blood. We're all very enthusiastic about you. My last question is about another shattering of public trust, which is ICE. As you know, people are being detained, people are being denied the process. We even had in the Boston Municipal Court someone picked up in the middle of a trial. ICE is in our courts. They may be sitting quietly in the back. We have no idea what they might do next. And though generally recording is prohibited in our state courts, bystanders do have the bystander right to record, and the rules do permit judges discretion to allow recording when they feel it is appropriate. So my question to you is, would you allow people in your courtroom to exercise their bystander right to record ICE?
I would. I think that that's exactly what you said. It's something very important to just, in terms of accountability. I think very limited circumstances, I would want to, I would want to just confer with the court officers. I think one instance, there's a reason they have the guidelines which say not to record in the courtroom, which is for the privacy of the other people in there. But I think even in those instances, let's say there is a family there that doesn't want to be on the recording, the court officer could say to them, ICE is here. The judge has allowed the public to record them. If you'd like to wait in the hallway, until your case is called. We can accommodate that, just so that people know that if I were the judge, that I've allowed that, and that people have a right to go somewhere else if they want to go somewhere else till their case is called. But again, in terms of what you're talking about, the public bystander, I even think if someone started filming us, they might just leave the courtroom, which I think is something to consider as well.
Think so too. Thank you so much.
Thank you.
For the-
Mr. Chair, can I say one other thing before you go, if I may? You know, I talked about all your supporters. I neglected one. Your chair, Councilor Ianella, big supporter. I want to say that before he got a chance to say it.
I just want to follow up on Councilor Dolan. This issue was brought up a week or two ago. And I don't go to court anymore. I'm more of a businessman. And I've asked attorneys as well as about 6 or 7 judges. I know we have a couple here. And maybe Councilor Dolan knows obviously better than I do. My understanding, because some other criminal lawyers are in the courtrooms every single day, that ICE is always outside the courtroom, not inside. Everyone I've talked to says there's no situation that they've even heard of. I know we have 2 judges here today that ICE has actually been in the courtroom. What's your understanding of that?
I agree with that. I don't think that and I'm in the courts every day. I don't believe I've seen ICE in the courtroom itself. I believe if they're there, they're probably waiting outside the building. That's just been my experience.
Yeah, that's what I heard. So the recording might never come up.
It may not.
And more likely than not, it wouldn't come up. That's what I hear. I think Councilor Dolan wants to say, so you want to?
Thank you, Councilor. I have seen it and heard of it, so I think that it does happen. It's not a constant, it's not every day, but it is possible, and
Okay, thank you.
thank you.
And you said you'd allow, you have the discretion, limited discretion to let someone record if ICE was in the courtroom. Under what other circumstances would you let someone record the proceedings?
I think there's if there's a case of great public interest.
If you could give, okay, I'm sorry to interrupt.
Well, I was just gonna say, if there's a case of public interest that maybe the media is interested in, those are cases where you would want to record. I really personally don't have a huge problem with recording. I mean, we're recording audio anyway. And so the only thing you want to just make sure is that it's not a disruptive thing within the courtroom. But we have media cameras there on a fairly routine basis in the court that I work in to record arraignments or to record hearings. And I think that's totally appropriate and it's totally allowed. Justice should be transparent.
All right, I don't disagree. What if, I had a client and he or she was arrested for something and the spouse was in the courtroom? Would you let them record? I mean, that's as important to them as the situations that Councilor Dolan were talking about.
If that were a motion that were or something that were brought to me as the judge, I would be inclined to allow it. And I think it's one of those situations where you'd want to at least let everyone else in the courtroom know there's a person here who wants to record this particular hearing. They will be recording that particular hearing so that they, can see what happened. But as long as everybody else in the courtroom is aware that that's something that's going to be happening, and again, as long as it's not disruptive to the court proceedings, I personally wouldn't have a particular problem with it.
Thank you. What's your position on conducting matters, pretrial conferences via Zoom?
I'm in favor of it. I think that anything that provides better access to justice is something that should be utilized. We have the technology now to be able to conduct hearings via Zoom or remotely, and I think that's a really important tool. In the court that I work in, all of our civil cases, if it's a non-substantive matter, are conducted via Zoom. Most of our mental health hearings are conducted via Zoom, and a lot of our pretrials and compliance and election cases, our non-substantive hearings are conducted via Zoom. And I think it's a really valuable tool that allows attorneys, defendants, victims to have the flexibility to be able to attend court virtually.
Totally agree. What do you do in a situation, assume you confirm, I'm sure you will be, and now you're at a certain court and it's the chief's policy. I want everyone to come in person, no Zoom. But I heard your answer. Remember now, you can't get fired. Okay, what are you doing to that situation? That's the policy of this court. I'm the chief, I'm in charge of this court. I don't want Zoom. What are you gonna do?
I would generally defer to the Chief Justice of the Court just to, so that there's some consistency there, but what I'll say is if somebody has an explanation and a reason why they would want to appear via Zoom, that's something that I would definitely listen to.
Like a childcare issues.
That's the exact type of reason that we would want somebody to be able to appear via Zoom.
Have another matter in a different court. I'm like Kennedy, he's at 3 courts a day.
Again, that's the exact type of reason we would want.
Sorry. But you're slowing down. What about continuances? Everyone I ask always says, yeah, no problem with continuances. But what if it's the third, the fourth? At what point is enough?
Is it something substantive or is it like a compliance election? Is it like the 4th jury trial date or is it the 1st?
Whatever it is. I mean, obviously, if it's a jury trial, there's witnesses or police, there may be court costs assessed. I get that, but you know, someone's not gonna tell you if they just got retained the night before in a big drug case and there's an arraignment in wherever court, they're gonna get paid. I can't tell you that. So generally, do you have a limit as to the number of continuances you would allow?
I wouldn't have a limit. Every continuance is completely circumstantial, so there wouldn't be a limit on the number of continuances that would be allowed.
And my last question is about pro se clients, defendants in criminal cases. Do you treat them any differently than someone who's going in front of you, a defendant with a high-powered lawyer like Kennedy?
They're acting as their own lawyer in that instance. I think a big piece of it is that you want to make sure that they have the information that they need to be able to handle the case properly if they're a self-represented litigant. For example, something as simple as understanding that they talk, then the other person talks, then they can ask questions and the other person asks questions. That's something you wouldn't have to explain to a lawyer, but you might want to be explained to a self-represented litigant so they understand this is procedurally what will happen today.
But would you say to yourself, this pro se defendant, she's doing a damn good job, but they're missing one thing. Would you ask a witness a question for clarification purposes that the pro se defendants missed?
I generally try not to put my thumb on the scale either way. I deal mostly with self-represented litigants when I'm handling clerk's hearings and small claims. And a big thing for me is to remain neutral and to allow parties to present their cases.
It seems to me, again, I remember not that many years ago with Judge Coffey at the BMC, where I was there quite frequently. I remember all those judges, but probably most of them are dead by now. But I have some recollection that they would ask questions. You wouldn't do that.
I think occasionally asking a question for clarification is definitely permissible. But again, the big thing for me is to make sure that it's clear to all the parties there that I'm completely neutral. If I'm just trying to get a clarification on a question that was asked, I look at that a little differently than saying, you missed this element. I want to make sure that you get that in because I think that, you know, you want to ask that question. That to me is, there's a distinction there.
Okay, and what about you're the judge and it's a young prosecutor, it doesn't have to be a young prosecutor, but my hypothetical, young prosecutor, and the defendant is someone you're familiar with because you've been in West Roxbury Court and this is a bad character. You have some recollection that he's been arrested 3 or 4 times for OUI and this guy is bad. And now he's in front of you today on an OUI. And the young prosecutor doing a pretty good job, but misses the public way. And then the defense attorney says, and if I say it the wrong way, because I don't do this stuff anymore, makes a motion for required finding of not guilty, didn't mention, what are you doing there? Or if the prosecutor, oh, excuse me, can I make a motion to open up the case? Like, what do you do in a situation like this?
The prosecutor's rested.
The prosecutor says, oh, while he's making that motion for the defense attorney for required finding, the young prosecutor comes, oh, excuse me, could I make a motion to reopen the case? Because the prosecutor, under my hypothetical, rested. What do you do in that situation?
The motion for required finding has to be allowed. The Commonwealth didn't meet its burden of proving each and every element of the offense beyond a reasonable doubt, and the defendant is entitled to a finding of not guilty.
Thank you. No, I agree with you. I don't have any further questions. Oh, I swear, this is the last one. Where are you gonna be on November 1st? I'll give you a clue. I'm gonna be in Chestnut Hill. I heard what you initially said on your opening. Ah, there he is. He got it.
Well,
And what side?
Yeah, that-
Right
that
here.
is always the
What
trick.
side are you gonna be
I
on?
know, I have to go with Notre Dame.
It goes that.
64 days of the year, I work for Boston College.
Okay. People don't, it's BC Notre Dame, November 1st at BC. As you know, the game will be totally sold out. I go to all the BC games. That's why yeah, they got Clemson this year too.
That's a tough game, yeah.
October. Yeah, that's good. I don't have any further questions. When your name comes before the lieutenant governor, probably next week, I'll be more than happy to support you.
Thank you so much, Counselor.
Thank you, everybody. That concludes the hearing. You
I'm going to begin by reading a letter submitted to the council by the governor. Dear councilors, pursuant to the provisions of Mass General Laws, Chapter 27, Section 4, I am pleased to nominate Angelo Gomez Jr. for appointment to the position of parole board member. Should the council confer its advice and consent, the nominee's term will commence immediately and expire 5 years from the date of appointment. Goes on to offer the nominee's name and address. I appreciate your consideration of this nominee resume attached for review. Sincerely, Maura T. Healy. And with that, I'll first introduce the council and then we'll introduce the nominee. We have Councilor Tamisha Civil is going to be with us, Councilor Mara Dolan. I know, well, Councilor Christopher Iannella, Councilor Terrence Kennedy,
Money.
Councilor Tara Jacobs. So, Mr. Gomez, if you'd like to, you can begin by introducing folks you brought with you, and then we can move on and hear statements from the witnesses you brought with you.
Good morning, Angelo Gomez Jr. On my behalf is my wife who's here to support me, and Commissioner Pamerson Ifill on probation, who will speak if allowed to do so.
Okay. Well, if you'd like, you can step right up and. We appreciate you being here. Please share what you have to offer.
Start?
Yes, please.
Well, good morning, and I appreciate the members of the council allowing me to speak on Angelo Gomez's behalf. As you heard, I'm the Commissioner on Probation. I've been working in the Massachusetts Probation Service for the last 32 years and have held several different roles and titles. Speaking about Mr. Gomez, I think his appointment to the board, I think, is the right person at the right time, given the evolution of what we've seen in the criminal justice system here in Massachusetts, the focus on criminal justice reform, the focus on rehabilitation, and what is needed and necessary. In addition to being commissioner, I'm also the president-elect of the American Probation and Parole Association. And that is an organization that has worldwide reach as it relates to probation and parole. Mr. Gomez is also a member who's also doing any number of different programs within the American Probation and Parole Association. So together, collectively, we have not just a Massachusetts view, but we have a national view about what is going on in probation and parole. But since we're speaking here about parole, when you look in 2019, 2018, the Council of State Governments, as well as the Pew Center Research, came and looked at Massachusetts, but they looked nationally at all 50 states. Massachusetts ranked as the state that sends the fewest people back to prison and jail, not just on probation, but also on parole. So it tells you that we are doing some good things here. That said, there's still significant need for focus and growth around rehabilitation, around accountability, but how we are addressing probation and parole systems in the Commonwealth. And I think Angelo brings a very unique focus about rehabilitation and the impact that that will have. You know, we get into these cycles in probation and parole where 20 years ago, you look at our system, both systems, the focus was on trail, nail, and jail. We have significantly focused the systems that are focused on treatment and rehabilitation and how we really work to change the outcomes of individuals who are on parole. And Angelo brings that perspective. We conversate almost weekly about our systems and how we can continue collectively to move these systems forward in terms of addressing, again, and I'll say this, and it isn't meant as an insult. 20 years ago in the probation and parole world, we used to hire people that wanted to be police officers. There's no knock on police, but many of them couldn't run a mile and a half, so they became probation and parole officers. Hope you got the joke.
Say that again? Say that again?
So who are you? He was former parole officer, but so look, if we are going to reduce and continue to reduce crime and recidivism in Massachusetts, you're going to need folks like Angelo, who understands that, look, we know how to hold people accountable. We are really good at sending people to prison and jail, but that doesn't solve the problem of people reoffending. Angelo brings the kind of vision that really, let's focus on treatment, let's focus on services, let's focus on support, let's look at employment, let's look at housing, and how we can do that kind of work to really focus on rehabilitating individuals and changing the trajectories of their lives. Angelo is very skilled in understanding what the social drivers of crime and criminality are in this state. And I think those are the important spaces and places that we need to move parole in as we move forward. I think there's a lot of progressive work that is occurring, but I think we continue to need board members who understand that sometimes a lot of folks we see are struggling in the social and economic factors. There are factors around education, there are factors around housing, mental health, substance use addiction. And I think given the depth and scope of his work from a patrol officer, probation officer, parole supervisor, and now leading that entire field services team, tells you that he didn't only grow up in the system and understand fundamentally from the aspects of probation and parole, because a significant portion of his population are also people who've got what we call dual supervision. And so I think this provides us with an opportunity where we can work both systems in a singular kind of focus and mission around rehabilitation and focus on employment and all of the things that we do. Probation has a lot of resources that we share with probation parole, and we have a lot of conversations monthly and weekly about how we can better leverage those resources and improve outcomes. He's data-driven, his mission and vision focus around the things that are really important to changing the lives of trajectories of people who are on parole. And I think his appointment to him becoming a board member will allow us to move the system. Look, the Sinelli killing is probably one of the more horrible aspects of parole in the Commonwealth of Massachusetts. And that shadow has been cast a long, lengthy arm about how we parole and how we supervise individuals in Massachusetts. And I think that we can achieve a number of different things. We can release people, but we need to be able to release the right kinds of people, and we need to release folks that we can work with to provide the kind of treatment and supports that will allow them to not recidivate, not be rearrested, and live productive lives in the Commonwealth. And I think Angelo brings all of those skill sets to the forefront. And I think he would be a significant, not just partner and asset, but really enabled to move parole forward in Massachusetts. So.
Thank you, Mr. Commissioner. As will be the procedure for the rest of the hearing, I'm just going to go around the council, see if there's any questions for the witness. And I'll start with Councilor Jacobs, my counselor to the right, although left at the moment.
I do have questions. I may be misremembering this. Is probation the source for GPS monitors in terms of
Yes.
equipment?
We are yes, we monitor about 3,600 folks around the Commonwealth, and about 400 of those.
350.
350. All right, so it's good. He's doing what he's working already. We used to have significant numbers, but yeah, so we monitor GPS for parole as well as probation. So we've got about 3,600 individuals right now in the Commonwealth who are on GPS monitoring.
My question was more so around the equipment itself. Is your department the one choosing what type of equipment to use when doing GPS monitoring?
So we just went out and we just replaced the existing vendor that we've had for 10 years. It used to be Allied or Attentive. We now switched to BI, which is Boulder Industries. Part of the reason for that change, the old we had about a 24-hour charge. So we issued a lot of warrants, a lot of violations as a result of that. We just switched to a new unit that has a 60-hour charge, portable monitor, so people aren't stuck to wall plug. And so we've gone significant reductions in the amount of warrants we issue simply for failing to charge.
Because I heard feedback on the new equipment that it.
I'm sorry, Mike. Can you just speak up a little bit?
I'll try.
That's not really a problem, you Tara.
I've heard feedback on the new equipment that it is, it talks and beeps, at times that can be disruptive towards productive reentry and in employment situations and social situations where it kind of outs people to, it's not discreet. It's not, as easily, kept from public scrutiny that, you're on this. And so I'm curious about the choice of that equipment and what your thoughts are around I guess the cost benefit of that, right? In terms of, I appreciate the longer battery life, but I have concerns about some of the other aspects of it.
So here's it. I mean, there are different features that we can turn off and on. And I think, we launch, April is when we switched it, by the end of early May, when we switched to that vendor, part of turning all of those features. Look, we had a lot of warrants issued in the past for people not necessarily understanding when their battery needs change. So those alerts only come on when individuals allow their batteries to start to drain down. So it's a reminder to charge a bracelet. I think sometimes it is unfortunate, where whether or not people in social circles, but at the same time, the fact that we have, so last year, the same time, in April last year, we issued 97 warrants on failing to charge. This year, 7, April. So there's significant benefit. I'd rather have an annoying beep than the police knocking on my door because I didn't charge my bracelet. So there's a cost benefit analysis that I think it is really important here. But we are going to, based on what we're seeing, we're going to turn off some of those features or keep some active.
In terms of when deciding who gets a monitor, are there criteria considered in terms of either their past behavior, current behavior? What is the standard protocol for deciding when a person should be monitored?
There's two things, and and again, this is a conversation that we've been having several times about who are most important. Typically in a probation and a judge's order. Then there are certain types of sex offenders, level 3 predominantly, and some level 2 or level 2, where that is mandatory. There isn't a lot of options there. So in cases where there's a victim or stay away or all of those. So there's some specific areas that we look at. Of the 3,600 individuals, I'd say about 96% of those either have a stay away, a curfew, a victim involved, or is a legislative requirement given the nature of the types of offense. So probation, we on our own can't decide who to put a GPS on. It has to be a judicial order.
All right, well, thank you very much. I appreciate that and information.
Just in general, I mean, with respect to GPSs, and I'm gonna talk about scrams a little bit too. Do you think GPSs in the system, either for pretrial conditions of release or post-trial conditions of probation, do you think they're overused overall?
You need me to put that on the record?
They put a lot of people on a GPS, yeah.
So like here on my, I'll say this.
I understand you don't order them. I understand the judge orders them. Although I think in parole, I think a parole officer can, but we'll talk about that in a minute, but do you think they're overused?
Yeah, I do. I do. And I think we are currently working with all of the chief justices and the court to come up with sort of better universal standards. We've been having these ongoing meetings and there's one coming up. We're looking at, again, we don't want to order GPS in instances where there isn't a victim. So we're seeing a lot of domestic.
Even then they can be overused. Like, you have to look at the circumstances of the case. There's one court when I went on a domestic, before, when someone's getting arraigned on a domestic, no matter how, not that any domestic isn't serious, but there are some more serious than others. No matter what the circumstances are, the first thing I do is walk into probation and say, do you have a GPS? Because I know this judge is gonna put him on a GPS, no matter, without even knowing the facts. He's gonna put him on a GPS on a domestic, every single one of them, okay? There was another judge that used to do that, retired recently. Judge Garland wrote a very long decision talking about how GPSs are an intrusion on people's privacy and their lives, and a significant hardship on people. What kind of things do you think probation can do to try to like persuade the judiciary to maybe lighten up on those? And by the way, there's one other thing. Apparently, you guys have changed, the GPS have changed, they're actually bigger than they used to be. I don't know what that's about, but I'm getting a lot of complaints about, they used to be like this big and now all of a sudden they're like that big. What's going on with that?
So a big part of that has to do with battery life. And as you know, one of the things, battery life. Part of the challenge that prior back, we saw a lot of warrants because the units weren't holding charge. Right. Switched to what we think is a significantly better, there's sort of this compromise between either we issue more warrants, arrest more people for not charging, not only is the battery life significantly better, but the straps, better tamper-proof signals. So the technology is improved. One of the ways that we have tried to address that specific concern, we have written language right into the contract that every time BI improves the technology, and they've told us that their next iteration will be a smaller unit. So I'm going out to their head facilities in September to take a hard look. But this
the point about them being discreet versus not discreet, with people being honest, you're just getting a job, or, you know, you show up for a job and you got this big thing on your ankle. People don't look at you funny.
So, yeah, look, I mean, I think there's a balance between public safety, because I think, you know, ideally, we would prefer that every person who got a GPS is the person that presents some level of risk. And I'm not saying that there aren't around. Part of the challenge is, again, you know, more often than not, if we're going to be recommending a GPS installation, is that either, you know, we've done a pretrial assessment on this individual, we've done a risk analysis. But I think part of this problem, the thing that we're trying to figure out is less violations, less warrants, less people going into custody, and the compromise of that is a larger unit.
Which brings me to the other point. They're definitely too quick to put out warrants on. A lot of these people, all you have to do is pick up the phone and say, come into court tomorrow morning. You don't need a warrant. The vast majority of them.
So the warrant issuance are down 50% already based on this unit. And because we don't have as many strap tampers or the kinds of alerts that used to.
But even with those alerts, okay, without an explanation as to what went on, something could have went wrong with the bracelet. Nobody's doing anything wrong, and all of a sudden they're getting arrested. In some departments, police departments that warrants go out are very aggressive in getting the people right away.
So if you said that a year ago, I would agree. If you say it now, no, we've seen significantly less issues around that. We've also created a unit that is on 24/7, and their job is to focus on what is a real threat versus what is just a nuisance alert.
Don't you think a phone call?
So all of those.
For a warrant?
So before any warrants are issued, we make several attempts to reach out and talk to that individual every time.
Okay. Scrams.
Scrams.
Okay, switching the scrams. You're in the hot seat, sorry, and I know it's.
I thought I came here on the council. Next time somebody
Started and just got to be going on it.
Next time somebody invites me to speak on their behalf, I need a.
A scram is a portable breathalyzer that people put on that sometimes they have to.
Anybody who you're charged with.
Day, okay? No, the biggest complaint I get about scrams is when people are out on scrams 4 times a day, and the last one's at 10 o'clock at night. If you run a scram at 10 o'clock at night? No, you know what happens? They miss them. You don't want to know why? Because if they're old people like me, they fall asleep at 9. Okay? And that happens a lot. And you're getting a warrant on them.
It's not all the time. Look, we make the calls. What?
I know, it's happening a lot, Commissioner.
So
I'm in court every day. I see it all the time.
So I'll say this, we are actually going out to bid on that because we're looking for different ways to monitor and track individuals. And we think some of this can be by cell phone with the biometrics and different scheduling. But again,
I'm not a big fan of scrams, and I'll tell you why. Okay? We have this whole system in place for breathalyzers, okay? Where we have the Office of Alcohol testing, test the breathalyzers the police use. They certify them every year. They go through this whole process to make sure they're okay. And guess what? They still have a lot of problems. These ones aren't even certified.
oh, no.
They're not, they certainly don't fall under the statute.
No, all of we calibrate every unit across the Commonwealth.
Records of those calibrations?
I can have you the information.
I'm not a big fan of them.
So,
I had one case where a guy down, we lived in Quincy, was on a scram out of Woburn. He blew in the scram, and it was like a 1-6. The police came within an hour and arrested him. They gave him one to the station. You know what his reading was? 0. He got hauled to court, missed a day's work, and released and said sorry.
So
No one said sorry, it was me. He was scared.
So I can't speak to that individual case, but
I'm just saying, I'm not a big fan of them. I don't think they're very accurate. I think they give false readings a lot, okay? I think they create a lot of issues for people. Same thing, you're at work, you're not in an area where you've got good service for the scram. You gotta go outside, boss, I gotta go outside and blow into my breathalyzer today. You know what I mean?
So I hear you. I also think there's a counterbalance to this on individuals who are the victims of crime and the potential damage and harm that occurs. And I think probation is always, and parole as well, caught in this rehabilitative mode where we're trying to give people opportunities and chances, and then there's also that accountability piece where I'm never ever judged by the 99 people we keep safe. We're always judged by that one instance. And I think, unfortunately, the system sometimes is so locked into that 1% of cases that can go wrong that sometimes it has this net.
Us to pay for that person?
No, and I'm not saying that, but I think, to be fair, we spend a lot of time trying to get folks the kind of supports and service. We don't.
It's not completely off track, because I was gonna ask him some of the questions of what kind of condition.
I prefer you ask them those questions. I'm just kidding. No, I think.
Can I just say something? A very smart guy.
I appreciate that. Well, look, I think the work that we're doing now is really a direct correlation to all of the concerns and questions that you all are raising about these issues, because I think probation and parole spends a lot of time trying to balance that. How do we weigh public safety against the need to ensure we provide individuals under our supervision and care and the supports and service that will allow them to be successful? And Mr. Gomez, I think, better than most folks that have come through here in this, offers that.
Thank you, Commissioner, and you're doing a great job.
I appreciate it.
Good work you're doing.
Thank you.
I really mean that.
Thank you, Counselor. I'm gonna let Counselor Jacobs have a follow-up and then we'll other counselors.
Last thing,
Not the GPS, right?
it still is actually, last thing, so. The charging question, but also these are wireless devices that work off what, like a cell signal? So this is a Western Mass heavy problem, although I'm sure there's other pockets across the state, but we have huge pockets where cell signal either is non-existent, very weak, or it doesn't work within old buildings. And when we were talking about data, Nominee Gomez and I, the Springfield office, which covers Western Mass region, has disturbing data trends. And I'm just wondering what your thoughts are around, is there an element of some of the factors of what it is to live in Western Mass and the digital inequities and the other?
So we know that there are rural parts of the Commonwealth, but one of the things that we've done with this new vendor, the old vendor had one cellular carrier. This vendor now has 5. And so we're hoping that if the system bounces off and it doesn't get a connection, it connects to a next carrier. So that's part of what we're working through.
We have little giant areas that have no carriers of any kind, literally.
So that continues.
Not roaming, nothing.
And that will always be a challenge. I don't care what the technology is, but the fact that we've expanded to more carriers, we've reduced some of that, but still it's going to be a challenge in spaces that you still don't have that kind of connectivity. And here's.
I appreciate your input on it. I'd love to hear more at some point of just what the factors are that are contributing to what's going on with the Western Mass District.
My favorite place to visit.
Wise. Zach?
I know that Councillor Kennedy, and we've also added a watch feature to GPS. The only problem is it has to be improved, and we're only going to be using that in really limited circumstances. So the next iteration should give us, right now, if we use it, there's about a 12-minute window. If somebody takes it off, we wouldn't know. So we're not installing it yet, but Boulder Industries has assured us that the next iteration of the watch. So we're looking, and the watch is no larger than this. So we've been really focused on that, and we've written it right into the contract that eventually we're going to bring to bear GPS monitoring through watches. That should remove that ugly feature that people are concerned with. I know you have.
Thank you, Counselor. Any questions?
Sure. Now that he picked on the police. So I have a question about, people call all the time and ask about having their records sealed. So do you have any thoughts about what the process is now and how it might be improved?
So we've beefed up and added a significant amount of staff to record sealing, not just sealing, but sealing and expungement. Last year, we sealed more than 53,000 charges. 53,000. And so we're continuing to focus on continue to expand that, make sure that that is streamlined, that it's significantly quicker than it has been in the past. So we're really focusing on sealing and expungements. But I've got an entire team of 12 people who are focusing on just those two spaces. But
But I've never done one. It's my understanding that people can do them without going to court. Some of them,
Yes.
is that correct?
Yes, all depends upon the statute. Sometimes, you know, you will be required to, but a significant amount of sealings are just individuals filling out the form, sending it into our office. We're trying to reduce that from about 90 days to around between 30 and 50 in terms of that. The expungements is a little more detailed, but, I think we are on the right trajectory with that because we've, some of the challenges for us in Massachusetts, and I think for a number of other states, we may seal a record, but that information isn't picked up in CJIS and by the feds. And so people, even though it might be sealed here, they can stay sealed at the federal level.
It depend on like an employer, right? Depending on what kind of, if you're gonna be a cop or, firefighter.
Yes. Oh, those are folks
You
that,
see it all. The public, can see it, right?
no.
All right, well, I appreciate you coming today. Thank you.
I appreciate that. We should buy you some malasados the next time I'm in your neighborhood.
Sorry, I have swimmers here, I'm sorry.
Malasados.
No, that's all right, you're in.
Thank you, Counselor. I went out of order letting Counselor Kennedy go, but thank you for your patience, Counselor Dolan.
That's okay. Thank you, Counselor DePaula. I have not a question about scram, but an observation that it's not always that the individual is falling asleep. It's that they can't fall asleep because they know they have to be up for their scram. I mean, 10 o'clock, frankly, is past my bedtime. And I had a client, so the real issue for him, his sleep was badly disrupted. I tried to get the timing changed. The judge didn't agree. I just hope that that will be part of your considerations moving forward. Fortunately, my clients, it's not long after that, he was suffering.
No, look, I think there's part of the challenge for us. I mean, probation makes recommendations, and I think, the current Chief Justices are really all committed to figuring out how we can improve all of these areas. And so these are ongoing internal trial court conversations. There's nothing worse than a probation officer getting a call at midnight along with that client and that scram trying to figure out what's going on. So we are also living a lot of that. So part of that is we're trying to figure out, one, let's put the right people on the unit. And then if we can figure out how to monitor, what we need to do a better job of is continues that when, if people haven't violated, get those cases back have a conversation with the judge. Again, we're not the only parties here. The district attorney's office more often than not have a lot of say about who has the unit. And sometimes we are just along for the ride, but that's not a negative. All I'm saying is that we live the same pain as many of the clients because we have to always respond. Before we used to have chiefs on call, now we've had to create an entire unit that's their job, responding to those alerts and trying to figure out which ones are legitimate and which ones are not.
Appreciate that. I do have a question for you. I haven't been a governor's counselor very long, got more calls about the nominee than about anyone. I've heard from people who have wonderful things to say. I've heard some folks who have concerns. The common theme among the concerns is that, as you put, well, you didn't put it this way, but what you said was he went from patrol to probation and parole. The common theme among the concerns is that he has so much of a law enforcement background. And they're concerned that therefore what he does as a parole board member have that orientation and therefore be perhaps at times needlessly punitive. What would you say to those people?
So I'll say this. I mean, I think there's a couple of things there that people that work on the law enforcement, they can't necessarily make the kind of deductions to determine what is fair and what's the kind of appropriate measure. I've been working with Angelo now for more than 30 years. What is glossed over is probation. At the heart of probation is about second chances. We live in this. He talks more second chances than I do. And sometimes I'm wondering if we're talking to him. But what I will say to you that he brings the kind of knowledge and understanding and the data-driven metrics that are really important to determine who were dangerous and who were not, and who deserves second chances. So the noise around his law enforcement background kinds of rules out. Any training, any education, any understanding and disregards any level of empathy that I've known for 31, 32 years of working with people and trying to do the right thing or giving them second chances. I think that narrative really is a false one, and it isn't one that, you know, as they say, dog doesn't hunger. Better word. He gets it and understands that parole, as it exists in Massachusetts, need to stay a path of reform. Also holding those folks that need to be holdable accountable. I don't think that it's necessarily a true representation of skill sets and his knowledge and experience in being able to work with people.
I appreciate that. I have no further.
Good morning, Commissioner.
Yeah.
Just want to read one sentence from Mr. Gomez's resume. The Deputy Chief of Field Officers has an extraordinary parole law enforcement experience and judgment in order to make critical law enforcement decisions on behalf of the agency and the public. How would you describe, well, first of all, would you acknowledge that Mr. Gomez has law enforcement experience? You acknowledge that? Do you think on the parole board today, we have too many people who have law enforcement backgrounds?
Look, I think, so here's what I'll say to that, and this is me speaking personally. I don't know that because people have law enforcement backgrounds, it is fair to say that they're incapable of making the kind of progressive decisions that, you know, give people opportunities to be successful. Because I think in order to understand that, he understands the front end of how and why, what are the factors that get people in the system. I think his work, even though that is in his resume, doesn't necessarily capture his understanding of what it is to help people, you know, to allow people to be rehabilitated. And so I think he brings, you know, in terms of the parole board, you've got people that have worked in probation. And I think, you know, for me, I don't necessarily see myself as a law enforcement person, even though sometimes people use that. I see ourselves as really balancing the need for treatment and programming and services, along with making sure that people don't violate the law. He brings that mode in most that I've seen.
I appreciate that, but you don't have an opinion, and I appreciate it. You're not, it's Gomez's time today, not yours. I know we're playing the question, but you don't have a personal opinion as to whether or not the existing parole board has too many law enforcement people in that.
Not necessarily, because I'm saying it with a caveat. I think until, you know, I would want to see all of the decisions made by a board and, you know, people who get parole versus people who've done to be able to sort of draw that conclusion. And I think unless the data tells me anything different, I would say no.
I mean, myself looking at the parole board, like I'm a big fan of Dr. Vaughn. She has a social science background. I've worked with many members of the parole board who has a social science background. I've always been a strong supporter that we should have fewer members of law enforcement and more members on the parole board with a social science background. That's just my opinion. Do you have any thoughts on that?
So I think any board that brings, you know, balance and understanding, but I think at the end of the day, what drives what my thinking is, you know, the decisions people make, the experience, the expertise, and how they make decisions. And I think at the end of the day, I would want to measure that before I sort of make that broad conclusion. If enough people aren't getting parole, then I think that question comes into play more often.
Thank you very much. Thank you.
Can I just follow up on that?
Yes, Counselor.
And I just want to follow up on that. I'm just looking at the members. We have Nominee Coleman, who was a defense lawyer before he became a parole board member. You have Dr. Barner, which you indicated, is a clinical psychologist. Edie Alexander, I guess you could call her parole board as a parole board member from law enforcement because she came out of probation. But like yourself, I don't think she would consider herself law enforcement at all.
I've been stopped too many times to
She was very, very progressive when she was over in Roxbury in terms of what she does. You have Sarah Kaufman, who's a licensed social worker. And I'm not sure, Jim Kelcross, who had a private law practice up in Newburyport, was a state representative, but never in law enforcement. And Rafael Ortiz, I'm not sure what his.
Probation officer.
Okay, probation officer. So I guess 2 out of these members would, in theory, be considered law enforcement, but the vast majority, I don't think are.
I appreciate.
Councilor Ferreira and then Councilor Anello, and if you have anything.
Just to balance us out a little bit. This week, I got a call from somebody who just got out, cop, civil rights violation, did 3 years, no D reports, model prisoner, went up for parole 2 or 3 times, denied. He literally asked me to sue the parole board for not letting him out because there's discrimination against cops. So that's the other side of things. I told him I don't think he has a suit, of course. But do you think that there's disfavor to allow law enforcement people out on the street?
Look, I mean, I think individuals should be judged on the individual merits, we say in the world, in addition, I teach at the college level a lot. And we talk a lot about parole begins on day 1, you go to prison or jail. And so I think people shouldn't be judged by what their careers were, but really about, once you go to prison or jail, how have you complied, what kind of programs, what kind of prospects you've sort of skill sets you've developed. So if that is brought to bear, I think it is wrong.
So you think is what?
I think it is wrong if that is being used as a lever to deny people parole because they're police officers or law enforcement. I think it is
Well,
fine.
it's true. And he did all the time, but I was just wondering if you think that's a bias.
No, I think it's fundamentally unfair because it just discounts a whole group of people. And the vast majority of folks that I run into, look, I can tell you, I spend just as much fear as most folks driving and going places and doing things. So but I wouldn't make that kind of decision because the person was a law enforcement officer.
Thank you.
Just one real quick, I'm sorry. I agree with Councilor Kennedy's characterization of the parole board. I think he said 2 of the 7 members may be considered law enforcement. My only concern is if Mr. Gomez is confirmed, that to me would mean potentially people could consider then 3 members of the 7 board members as law enforcement. I think that's a lot. I would love to have seen 3 or 4 social science backgrounds on the whole. That's just my point. I have no further questions.
Thank you, Counselor. I just have 2 points to make. I'm sure you're very glad you're here, and it's almost over.
We're gonna confirm you, but.
Exactly. Exactly. Just for my own edification and clarification on 2 things that came up. When we think of GPS as a condition of release, is it accurate to say that oftentimes the officer might have discretion as to when that expires or when that individual may remove the GPS, or is that strictly on the
Unless the judge orders it. So a judge might say 6 months GPS and we will track the date from the disposition. But typically, we don't have control over dates or removals unless we go back into the court. And unless a judge makes that specific.
That has to come from a judge?
Yeah.
Okay, and regarding, I as a Central Mass counselor, I appreciate Counselor Jacobs advocating for Western Mass. I heard you talking about the progress you're making with the vendors and the forward-looking ideas you have with that, and that's awesome. I wonder if any of the vendors offer satellite connections, which has kind of become a thing now. And that's just a side note for thought. Because I know on my phone now, when I'm out in Western Mass or Central Mass, I can get satellite service because my provider offers it as I think it's in a beta program by them.
So I think there are aspects of it, but I need to double check that. I don't want to tell you.
Curious.
But I'll get back to you on that.
And then I do want to actually ask about Mr. Gomez. So you talked a lot about the all the things that we consider part of criminal justice reform. Some of them are moving, some of them are moving slowly. Could you just speak to not his philosophy, but a specific initiative or a specific piece of progress that Mr. Gomez, of having been personally involved with?
Well, about a year and a half ago, they had more than 450 individuals on GPS. He's fought to drop that now to 350. And as we continue to conversate, I think that number is going to get lower because one of the other things that he's really concerned with, has been concerned with parole officers actually installing GPS and leaving it on for infinity. His concern that is too long. And so he's working to really bring about something that you all are really passionate and care about. We spend a lot of time talking about that. How are we going to make sure that GPS isn't just this babysitter for individuals who may not necessarily need it? And I think that's an important part of this. I also think he's been focusing on looking at employment and treatment and housing to ensure that once individuals are released on parole, they have some place to stay. We know the big drivers of that. If you can't find people housing, forget talking about treatment. Find them housing, you find them treatment, you find them employment, those are the big three. And then if you can find some of the mental, and that's the areas that he's been working on to get his field to think about.
Thank you. And then the last thing is, I just want to make sure I understand correctly your perspective. It sounds like, and in speaking with most folks in this area, when we think about law enforcement and being a career in law enforcement, increasingly, like in other professions, medicine, education, a component of that work, someone who's applying or interested should know, is increasingly overlaps with social work. Would you say that's fair to say?
Yeah.
That it's not a warrior mentality, it's a rehabilitative, reentry, and yes, public safety, of course. Is that fair to say in your estimation?
It is. Look, I mean, I think anybody who's looking to get in law enforcement should have an educational, social work, treatment, mental health, substance use disorder background, because then you were beginning to understand the poverty and the social drivers, crime and criminality. And I think, so I am not going to say because somebody is a career in law enforcement that they don't understand those factors. I think all of those enhances our ability to do the job and be more effective. But I think what is really helpful in this space is that if you understand all of these things, an essential part of a probation and parole officer, our primary job is to get people services and get them help, but also making sure that they don't reoffend or go back to prison or jail.
Thank you, Mr. Commissioner. I just want to add, it's great to have you and Massachusetts represented on the national level. So I appreciate your leadership there.
Thank you. I appreciate it.
You've been through the ringer with the council. I don't.
I used to box professionally, so here's my offer. Here's my offer to the council. Anybody feeling froggy? Just leave.
Yeah. Thank you for being here, Mr. Commissioner. We appreciate your time. Yep, you're welcome to vacate.
Don't want to violate protocol.
Thank you, sir. Is there another witness on your behalf, Mr. Gomez?
I do not, Councilor Parole.
Okay. At this. Yeah, that was worth at least two. In that case, at this point in the hearing, we move on to hear if there's any witnesses here in opposition. And I understand there is, yes. So if you'd like to join us at the table.
You want me to be any?
If you wouldn't mind you wouldn't mind appearing over there. It's for the recording, your voice. I know the council is familiar with you and your work, but could you introduce yourself and offer your statement? Thank you.
Hi, my name is Patty Guerin. I've been a criminal defense attorney and a civil rights attorney for about 40 years. And the last 3 decades, I have been doing a lot of parole work. I've been running the Northeastern Law School Prisoners Assistance Project, and our students go in front of the board 20 times a year. I have a lot of parole cases, so I'm pretty much focusing on parole the last 20 years of my life, I would say. And I'm not here to testify in opposition to Mr. Gomez as much as I'm here to testify about what the parole board needs on it. Mr. Gomez and I have only probably crossed paths about a handful of times since I've been there, because I work at the front end of the system, getting hearings set up, getting people representation, making sure the hearings are conducted fairly, getting them the witnesses and experts they need, getting the votes we need. And Mr. Gomez is at the other end of the process, which is when people actually get a parole vote. how to take care of them in the community. That said, I know there's a lot of concern both ways. I know a lot of people who are in parole. I've had a lot of people call me and express opinions, both good and bad. So I want to talk about what I think the parole board needs, because I think decision on this job is incredibly important. I mean, people on the parole board control how many people's lives as to whether they're going to be free or not. I mean, people don't realize how important this job is and how much work it is and how hard it is. And people don't really appreciate what a fabulous job Tina Hurley did when she was chair. It's a mistake. I don't know how the governor made it to let Tina Hurley not be reappointed, but here we are, and we're gonna get a new person. Mr. Gomez can talk about if he's had conversations about becoming chair, but let's just presume that that's what's in store, because that's what happened with Paul Tressler and Gloria and Maloney and Josh Wall. And as soon as the chair left and a new person got nominated, they got named chair. So what do we need? Well, you're right. If Mr. Gomez gets on, we have 3 people who are coming out of probation. 3 out of 7 out of probation is a lot of law enforcement. People treat that job differently. It's not straight law enforcement, but it's a concern when there's other spots and other jobs that we need. It is not to say he couldn't go in and do the job as a former probation officer, yes, but what do we need? We need another psychologist. We have 1 forensic psychologist for over 3,000 hearings a year. 1 forensic psychologist. Charlene Bonner is drawn in for consultation on 1 million cases. She has to do almost all of the cases coming out of the treatment center because those are such complex, difficult cases. Why don't we have another person with a background? She's a forensic psychologist. We could use a clinical psychologist. We could use an expert in brain development. We could use an expert in emerging adult work. There's so many spots that we need that we don't have. We have 2 attorneys on the board right now. I mean, two attorneys on the board now, but Jim Kelcourse is not a practicing litigator. He doesn't have a background in civil rights or defense work or anything like that. Tonomy's the only person who has Tonomy Coleman is the only person who has a background in that. And you all know Tonomy has applied to be a judge. So do we need another lawyer? Sure, we could fill that spot with a person who's got a background in civil rights or a background in criminal defense. It would make sense. I mean, there's a law that has to be followed, that there has to be a forensic psychologist on the board. There must be. So shouldn't we have another person on there as a backup too? I mean, you don't want to go months without a parole hearing if something happens and Charlene Bonner can't be there for a while. I mean, I'm hoping that never happens. I hope she's there forever, but I don't know. I think it would make sense. I think if we think of progress for the board, what the board could do, you'd lean in favor of another person with a background in psychology, perhaps a person with a background in civil rights law. Those are the kinds of things you need. I hope that when you talk with Mr. Gomez, you can ask him some questions about some of the things I've been concerned about, what goes on in the community, in the office of parole officers. I'm wondering why in the world we still make people take polygraph tests when they're not admissible in court. They're totally unreliable and they're used to intimidate people. People have to come in and answer these incredibly personal questions. They're intimidated. There's often cultural differences between the person who's doing the questioning and the person who's answering it. That makes the polygraph go crazy. And even though we say, oh, we don't violate someone solely for failing a polygraph, there has to be something else. It's just an abusive thing to do. Why do that to somebody? It's worthless as far as reliability goes. It's just a tool to intimidate people. I am a big fan of getting people off of GPS. I am disappointed that we still have so many people on GPS. The new GPS device is a nightmare. It's huge. It's like this big. It's completely uncomfortable. It makes noise all the time. My clients tell me they just can't bear it. It just disrupts their life. It prevents them from being able to mix into the community and go unnoticed. You wear a machine that's big around your ankle that blasts noise all the time. Everybody knows you were formerly incarcerated. Everybody will ask you what's going on. So the termination procedures, there needs to be new policies for termination. Right now, the parole board looks at, sets a number of years. You have to have been incarcerated this long to be able to apply for termination to get out if you have a serious offense. Science tells us, again, go back to science. Science tells us that if you've gone 3 years without a violation, you're not going to violate. You're not going to violate your parole and commit a new crime. If you've gone 3 years, science tells us that most people who are going to violate, and I'm not just talking little rule violations, I'm talking law violations. Law violations, you're not going to violate if you've gone 3 years. So let's set some new standards for getting people off of parole. Those are just some ideas. I am hoping that Mr. Gomez gets this job. He'll get working on those things. I would prefer if you look for a psychologist or a criminal defense attorney or a civil rights attorney, but whatever it is, I hope we work well together.
I agree. Thank you.
Attorney Guerin, thank you for being here. I know how passionate you are, and I've learned a lot from you about parole since I've been on the council. I do want to give the councilors a chance to ask any questions. Let's see if I can manage to go in order this time.
You need to.
I'll start.
Whatever order you want.
Start with Councilor Ferrer.
I was just wondering, well, with the applicant's resume.
I've listened, I've looked at it and I think I have a pretty good idea.
Do you think he's qualified?
Yeah,
Okay, I do too. But just so it's clear, he's got an associate's degree from a community college. He's got a bachelor's degree in criminal justice from UMass Boston. He has a master's degree in criminal justice from UMass Lowell. He's been through.
Counselor, I have 9 graduate credits.
Graduate credits. Okay, I'm sorry. So you're working on your master's.
I have not finished.
Okay.
Currently working.
Thank you for that. But you've been through extensive training, sheriff training, probation training, special state police officer online, and you still train annually, correct?
Yes.
Massachusetts Core Management certified. You're a certified trainer for fair and impartial MPTC, Mass Police Training Council, correct?
Training for policing curriculum.
You're an instructor.
Yes.
You've been to the FBI leader school. You have a certificate in investigation.
Yes,
You're bilingual. You speak Spanish.
I do.
And your first job was actually a sessions clerk in the probate and family court. I bet you learned a lot there, correct?
I did, sir.
And you've been in law enforcement, or you've been in probation, not law enforcement, so to speak, not a cop, but you've been doing parole work for how many years now?
12 years, sir.
12 years. Good. And you understand that our only job here is to say whether or not the person's qualified. The governor gives us people. Would you have us just say no to everyone until we find somebody that has a certain degree?
I think I disagree slightly on how you stated your role, but you should know what it is. So I would just say that I would hope that the governor's council will be looking for the best person to fill the job. And the governor does make nominations, but you all can make suggestions to the governor for who to nominate. Anybody can. Any of us can make suggestions to the governor for who to nominate.
Thank you.
Thank you, Councilor.
Yeah, I just wanted to say, it's wonderful to meet you in person. We've spoken on the phone many times. I have been the beneficiary of your exceptional expertise on a particularly difficult case. I really appreciate it. Just as I appreciate your expertise now. And let's follow up. I want to get the science on going 3 years without violations. important science. It's something that I've observed. In the practice. I'm glad to know that there is science. Back it up, and I appreciate all you've done today.
I would just recommend a great book for anybody who wants to read it by someone who worked in Massachusetts for a long time named Vinnie Schiraldi. And he wrote a book on mass supervision. And it's really got all the statistics in it, all the background about how our country is overseas. I'll send it, the name and the link to it to you guys.
Is that counsel? Sorry, I know.
I do. Good to see you again.
See you.
I was a little surprised by your testimony, to be quite frank. I personally think he's qualified. But it's 3 out of 7. It's 45%, give or take, of the parole board. Some type of what I would consider law enforcement background. Is that too much? You don't think that's.
No, I do think.
Excuse me. I can have my, let me ask you a question. To me, you didn't think it was too much. My question is, what's too much that you would speak here and say, he may be qualified, but I'm speaking in opposition of this guy because we need another sociologist, we need another psychologist like Dr. Bonner. We don't have enough. So is 45% too much? And if it is too much, are you opposed to his nomination? He may be a great guy, he appears to be a nice guy, has a nice background. To me, it's about, is 45% of that parole board with law enforcement background too much? That's the question at the end of the day. I'm asking myself, so I'm asking you the same question, and if it is, are you still not sure if you support him or opposed to him?
I think that I maybe didn't say it loud enough or misunderstood. I was saying that I'm not opposing him as a person I know and a person I've worked with. I'm opposing him because of his background, because we we need what I said. We need a psychologist, we need a civil rights person, we need a more variety of people on the board.
Okay, so, great guy, at least these are my words, he's a great guy, but to you, maybe 45% of the parole board, if he's confirmed, is too much, and because of that, you're here in opposition.
That's right. That's said more clearly than I said it.
It's like, that is my concern. That's at the end of the day, would I rather have 45% of the board with a social science background? You bet I would. You bet I would. That's where I come from, and at the end of the day, obviously I'll hear from the nominee, but that's where I come, and I think we're on the same page. Thank you.
Thank you, Councilor. Councilor Kennedy?
Nice to see you, Patty.
Nice to see you.
I always enjoy when you come because you always provide a lot of useful information. What was Tina Hurley's background?
That's a good question because Tina had been in parole her entire career. She
Exactly.
started out in parole when she was in college and she never left.
And how did she do as a member of the board and chair? You're rating her.
I thought Tina was fabulous.
She's fantastic,
And I
right?
thought part of the reason is because she had so many different jobs in parole. I mean, she was a parole officer, but then she ran groups. She put together a women's group and she ran that women's group. She put together other kinds of support groups for people in parole. She did social service kinds of things.
Exactly. And her background in terms of the job she's had is not very different than this nominee's, is it?
Tina wasn't a
Officer.
Tina wasn't a correctional officer. Tina Hurley was not a correctional officer.
Well, obviously not, but I'm talking about in terms of role and parole and probation, it was not that different.
I can't say that. I don't know.
Well, she was a parole officer, right? She was in management as a parole officer at one point, right?
She was a hearing examiner at one point.
He's a parole officer, right? Now in management, right? Former probation officer, right?
Yeah.
And by the way, I've spent the last 42 years going into courtrooms almost every day and dealing with probation officers almost every single day. I dealt with him when he was a probation officer in Middlesex Superior Court. And I have to tell you, I don't know a single one of them that considers themselves law enforcement. It's kind of a hybrid type thing where they, you know, hopefully they're trying to help people get back on their feet, not just monitor them to turn them over to the court. That's the role that probation was set up for originally. And I think most of the people I know that are doing that job, they're almost like social workers in terms of doing that. Yeah, they have a role where people go off the rails and they have to bring them in front of a judge and sometimes recommend incarceration. We all know that has to happen sometimes. We don't necessarily like it, but it has to. But when you talk about law enforcement officers being on the parole board, I really don't look at those two probation officers, especially Edie, who I know. She was the furthest thing in the world you could consider as law enforcement when she was in Roxbury. She was not like that at all. She was running programs. She was running programs for the homeless. She was doing a lot of things when she was in Roxbury Court. So I struggle with calling them law enforcement. Now, that said, the statute does provide, it's indicated that it has to have a social worker. It also says you have to have someone from law enforcement, right?
Say that,
Someone with a law enforcement background in parole. Isn't that one of the categories that?
well, it's not mandatory, it's one of the possible categories.
But that-
Psychologist is mandatory. Psychologist is.
So I know the psychologist, and you know that Dr. Bonner is my dear friend and she's doing a fantastic job. And we had two at one point, but unfortunately, she got ill. I think it was Dr. Gavin, was it? She got ill a short time after getting on. I'm just struggling with calling them law enforcement. I agree parole is more law enforcement, a parole officer than a probation officer. I agree with that. They have a different role than a probation officer. But Tina Hurley came from a similar background, and frankly, I'm devastated she left. I think the parole board was working incredibly well under her as the chair. And it's unfortunate, but I see him coming from a very similar background. And I don't see any reason why he can't, and I hope that he's confirmed, that he would continue along the same path that Tina took in terms of how she ran things. I hope that would be my expectation of him. But
I don't know what to tell
you
you.
never know.
I view probation as law enforcement. That's the role they take.
We used to have, pre-Sanelli, we had police officers on the parole board. We had prosecutors on the parole board. You were there, you know.
I agree. I agree.
You
Then
know,
much-
my friend John Kivlin, who passed away, was a really tough chair of the parole board. Way back in the beginning of the time, he was a lifetime prosecutor. Okay, you had a lot of people that it used to be a much stronger in terms of it being members, much more than 45% members that came from law enforcement way back in the beginning of the time. You'd agree with respect to that, things have improved.
Oh, yeah, definitely.
Yeah. And what do you, putting this nominee aside, what do you think of how the parole board's operating right now with those law enforcement people on it?
I'm worried about how the board's gonna operate without Tina Hurley. I mean, I'm really worried about how the board is gonna be operating without Tina Hurley.
I'm asking you how they're doing now, not what you're worried about.
They were doing well with Tina Hurley.
All right. Pretty good grade right now, right? Even with those other two law enforcement people on there, right?
They were. But
You're worried that they might not be if he becomes a member.
he had a big influence on how the board ran, and I'm worried to see what's gonna happen.
Sure, I understand that. And you know, and we, that's why he's here, so we can ask some questions about that. But I'm gonna ask you one last question. Do you think the parole board needs to be expanded?
Yes.
How many members do you think there should be? 9, 11?
I would say 9 is a good number. Worked on some statutes that we've hard to draft and be filed to include it.
I agree with you 100%. And do you think that they're underpaid right now?
Yes.
You know, they work pretty hard for what they get. Correcting this to the people behind them.
Days all, I'm trying to keep up.
Right. Thank you, Patty. It's good to see you.
Thank you, Counselor. Counselor Jacobs.
I just had a couple clarifying questions. First off, it's good to see you, and I always enjoy hearing from, from you and your expertise in the area and all the work you do around parole and clemency. So when you mention lie detectors, what's the context that those are being applied? I'm not aware of lie detectors being used, so who and when and where and why are they being used from your understanding?
Well, they're being used with one particular group of people as a mandatory thing. Anybody who's on parole, who has served time for a sex offense, gets put on these conditions that are 25, 30 years old that should all be thrown out. It needs to be rewritten totally, those conditions. But one of them is a parole, I think it's a polygraph at least every 6 months. And then I have seen the board say other people should have a polygraph, but it's mostly focused on people who have a sex offense on their record.
I see. So it's interesting you mentioned that because one of my understandings is, and we're trying to wrap up for assembly, but I didn't want you to have to wait. For sex offense, the procedurals haven't been updated in a long time and everyone goes to the highest level rating is my understanding of what's happening on the parole outcomes when there's a sex offense issue. Is that your understanding as well? Level 3, I believe, they go right to level 3.
Well, it doesn't have to.
And
be
those
that
kinds
way.
of like oversight.
It's tied in with what the SORB rating is. So the Sex Offender Registry Board gives everybody who gets out a level 1, 2, or 3 rating. And then the parole conditions, the parole board decides to line it up with what the SORB rating is. And that's not so much mandatory or required, but that's how it happens. And then parole board has these things that they loosely refer to as attachment A because the conditions are attachment A to their policy. And those are horrific conditions that are put on everyone when they first get out. And then a lot of them become subject to the discretion of the parole officer. In other words, somebody could have certain conditions on them and it'll say subject to discretion of PO.
I'm gonna skip the rest of my questions just to the last one. Amongst things that you didn't mention are having somebody on the parole board who has experience having been personally incarcerated. What's your thinking around that?
I think that's gotta happen. That's part of what the statute is proposing, a larger number of people on the board. Even if it was only if it goes to 9, I think that would be, one of the people would be somebody who's got former experience with the criminal system.
I think so too. I appreciate that. We're gonna have to wrap, so I would ask you a couple more questions, but I'll follow up with you another time. But I appreciate you coming and thank you for all your information and your opinion.
Attorney Garrett, as was just mentioned, we're going to recess to have assembly, but as I said, I appreciate you being here. A lot of the issues you raise are things I think we're going to hear when we're hearing from Mr. Gomez. So thank you so much for being here. And with that, this hearing is in recess.
What time?
Just one.
Go ahead and call our meeting to order. I'd like to recognize Counselor DiPaolo for a prayer and for leading us in the Pledge of Allegiance.
Thank you, Lieutenant Governor. Today, I ask we offer our thoughts to those in our community who are currently scared about the potentiality for being caught in the unproductively broad dragnet that we see happening in our country. Pledge allegiance to the flag of the United States of America and to the republic which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Sorry to interrupt what sounded like a very productive hearing, and I will try and move us through this quickly so we can get to it. I'd like to recognize Counselor. Just going to go ahead and get through our meeting as quickly as I can. I know you guys have a very productive assembly happening. Can I recognize Counselor Dolan for a motion to record advice and consent for the financial warrant?
So moved.
Is there a second? Seconded by Counselor Jacobs. Any further conversation? Seeing none, all those in favor say aye.
Aye.
Any opposed? The ayes have it. I'd like to recognize Counselor Kennedy for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So moved, Governor.
It's been made. Is there a second? Second by Counselor Civil. Any questions or comments? Seeing none, all those in favor?
Aye.
Any opposed? The ayes have it. And today I know we have 3 new nominees. We'll just run through what we think expected hearing dates might be. The Honorable Jennifer M.D. Allen to the position of Associate Justice of the Appeals Court. I understand that Counselor Civil is going to hold a hearing on June 25th at 11 a.m.
Yes.
Accurate. Okay, we got 1 in the books. And then we've got Andrew Don to the position of Associate Justice of the Juvenile Court. Counselor Ianella, I don't know if you have a date or a time for the hearing. Perfect. So we're going to work on that one. And then Nabal Reheb to the position of Associate Justice of Juvenile Court as well. Counselor DiPaolo, I don't know if you have a date for that one yet?
No, I'll be corresponding with the council about that.
Okay, perfect. So we've got 2 we've got to schedule, 1 that's been scheduled. I don't think we have any other business, so I'd entertain a motion to adjourn.
So moved.
Motion's been made by Counselor Jacobs, seconded by Counselor Ferrer. All those in favor?
Aye.
All the opposed? None have it. Ayes have it. There you go. All right, let you guys get back to your hearing.
Of the governor's council, we've had a chance to hear from witnesses, and now it is time to hear from our nominee. If you have a brief statement to offer, and then the council will have a chance to ask you questions.
I do. Good afternoon. My name is Angelo Gomez Jr. I want to thank the Governor's Council for taking the time to meet with me, discussing the work of the Parole Board, and for considering my nomination today. Thank you to Governor Healy and Lieutenant Governor Driscoll for your support and nomination to the board. I also want to thank Sonia Altamirano and her team for the guidance. To my wife and family, thank you for your support. I want to take a few minutes to tell you a little bit about my background and why I want to be a member of the Parole Board. I'm in my 31st year of public service, and I feel like it was yesterday. I've worked at the Parole Board since 2012. In all my positions, I've worked towards providing the public and those I've supervised with opportunities. The opportunities consisted of providing service, guidance, and listening to concerns. I've helped clients manage the criminal legal system that can be overwhelming to most and be viewed as unjust at times. My goal has always been to do my job in a professional manner with empathy and to provide a sense of dignity throughout the process. I also want to share a saying that I was raised with my mom, with my parents, and it's "sed justo," which translates from Spanish to English to be just. My mom raised me and would remind us that everyone has value. Growing up, I was faced with many of the obstacles that our clients have also faced. I've had housing insecurities, financial insecurities, food insecurities, educational obstacles, and difficult cultural obstacles. My family often depended on agencies that provided services to provide some sense of hope, direction, and empathy. Often, we were met with what felt like disdain and made to feel inferior. She fought for what we needed, which was someone to listen and to provide some service. My mother had a 6th grade education from Puerto Rico. My father had a 2nd grade education from Puerto Rico. My parents instilled values of respect for others, helping your neighbors, working hard, valued education for all of us. My mother taught herself to read and write English when she came to New York from Puerto Rico. My dad could not read English and read very little Spanish. He spoke English with a very heavy accent, and the more stressed he got, the worse his English became. He mastered his memory of signs, products, colors, and objects to understand what he needed, and he was very good with money. Both of my parents worked as laborers in various jobs such as maintenance, restaurants, housekeeping, factories, and the like. My dad retired with a very small pension. My mom had no pension. My brother is a school teacher. My sister's an account executive. My other sister was a dental hygienist. All of us attended college or obtained required certifications. My parents would always say, work hard, go to school, treat people well, help others, and believe in God. They also wanted us to use our education to help others and to join the workforce to represent people who could not speak English, the marginalized, and most importantly, to be kind when we did so. I also worked various jobs. I've worked at furniture stores, retail sales, shoveled snow. I worked at convenience stores. I cleaned houses, camp counselor as a Metco bus monitor, the YMCA, and so on. All of those jobs built character, as my dad would say. I worked full-time while attending college. College took me several years longer to complete, but it was all worth it. Along the way, my story developed into success, led by my parents' influence, the help of many kind people, the help of various public and private organizations that invested in giving me and my family an opportunity to develop and succeed, not a handout, a hand up, because we always worked hard for what we did. I believe many of those that come before the parole board share similar experiences and are also looking for a hand up and equitable outcomes. I can relate to the experience of others and will apply the value of treating each person before the board as an individual. Listen to victims' input and will continue to provide a commitment of understanding during the parole process to all affected parties. Which goes back to sed justo, trying to be just in all we do. In doing so, we build strong communities that focus on hope and developing positive outcomes during the journey of life that we all share. In closing, to confirm to the parole board, I will use my experience, apply the rule of law, education, training, and engage all stakeholders in the process. I will also listen to victims and the community to help inform my decisions. I do understand the decisions of the parole board, I do understand that the decisions the parole board makes are vested in public safety and reentry opportunities, while also causing concern and pain for others. I am confident that I can meet the challenge ahead of me and serve the citizens of the Commonwealth as a parole board member. Thank you for the opportunity.
Thank you very much. And with that, we're going to hear first from Councilor Ferreira. Before we go around the table. Yeah.
Chairman, just very quickly, I think you have a great resume. I love your story. The man to my left, Councilor Parole, spends an awful lot of time working with parole, juvenile justice, formation of the brain. He's an all-star and he's a huge supporter of yours, which speaks volumes to me. And also a friend of mine, high school friend, BJ Jackson, recently retired from the parole board. I text him about you and he's a fan of yours as well. So you passed that litmus test. I think you're gonna make a great board member. I agree with Councilor Kennedy. I don't look at what you've done in the past as law enforcement. It's a hybrid for sure. More mentoring, helping people than it is enforcing the law. So I'm gonna vote for you when you come before us. Thank you.
Awesome. Thank you, Counselor. And now we'll hear from Counselor Jacobs.
Hi, good to see you.
Hi.
Thank you for coming out to North Adams and giving me a significant time during which we had a really interesting and far-reaching conversation. We touched on a lot of topics. Some have already been touched on today here, but so many more. I wanted to focus today on just a few areas, some that we did talk about, some that I don't know that we spent a lot of time talking about. One of the things we did talk about was in your role, you have experience nationwide with associations around parole, understanding how different states conduct their parole process comparatively. And we did talk a little bit about how long, well, a few things. How overburdened our current parole board is, the number of hours that they're putting in. I heard from parole board members that they're working up to 7 days a week. They're putting in over 90 hours a week. Honestly, it doesn't sound humanly sustainable level of work. But add to that some of these hearings are going 3 and 4 hours long. And meanwhile, between Diachenko and Mattis and clemency and the general order of operations for just your normal course for parole hearings coming through, it's an enormous amount of work that they're trying to get through, and there's an impact on the efficiency of scheduling. I hear the Mattis hearings are really scheduling out for years to get through it all. All of that to say, I'm curious about your thoughts about the nature of how hearings are structured, how they could be more efficient. If they were to become shorter, what would you prioritize in terms of focus? We did talk about the relitigating of the offense in the course of hearings and whether that has a place there and what the focus in your mind ought to be. And I have more sub bullets, but I'll leave it there. It's a lot to throw at you. I'm just curious about your thoughts.
So thank you. That's a great question. With regard to the hearing structure, I know that the behind the scenes we're working with UMass Law and Psychiatry to kind of get the process together for the board in terms of what a hearing looks like, what questions are relevant, and actually what data the board is viewing to have that hearing versus, you're handed a package of maybe 500 pages, and do you need that, and what's relevant to the hearing process. In terms of efficiency, the board, as you noted, is very busy with many hearings. So one of, without criticizing the board, they do amazing work, is we've talked here about Dr. Bonner and her wheelhouse, a clinician, lawyers. I believe, my experience that I bring to the board would be a really strong reentry, that having a guide to have particular experts in their field and never limiting the board's ability to ask of others or someone before the board a question, but to try to focus and redirect the energy towards your wheelhouse. I'm not going to pretend to be a clinician. I have knowledge. I think I could ask a question if I needed to, so that would be one here. And the focus in terms of relitigating the case, I agree that some of these hearings are difficult, and the patterns of questions that are asked can be refocused to reentry and what the person has done to convince and meet the standard of being paroled. So that's where I stand on most of those matters.
So are you suggesting it's more a matter of looking at the packet of what this individual has accomplished, what they've done, what their focus has been, what evidence is brought forward, or would there be specific questions you might offer that you would use?
I think it's a combination of both. And so we're recently gathering that data. The product is done from UMass Law and Psychiatry. I think they finished their last report maybe 9 months ago. And again, I've never sat on the board, so it'd be really difficult for me to critique why they're asking a question, but I would say that having the most proficient use of what data the board has before it that's relevant versus I have a package and I have an autopsy that may or may not be relevant to the case, but is that the structure that we want for the board?
What role? I remember you mentioned it in the course of our conversation and I just wanted to dive in more, but what role do you think remorse or repentance plays in the parole process? What role should it play in your mind?
I think it should be acknowledged. I think it's very difficult. The hearings are open to the public. It's very emotional altogether. To try to get a client to have a very valid conversation in front of 50 people could be difficult. I believe most clients that come before the board express remorse. It's certainly asked of them what their view is. I think it's a relevant question.
Well, I mean, those are lifer hearings. The bulk of parole hearings are not open to the public. Those are the institution level parole hearings where, I'm fascinated what happens there. I have no idea. I have visited the parole board to watch lifer hearings a number of times and there's a lot to learn from that, but I have no idea if it's significantly different than what happens institution side. But I just wanted to talk to you about it because I think authentic remorse is a powerful thing, particularly towards forward movement in rehabilitating oneself and one's life. Having said that, the governor's clemency guidelines even allude to the fact that we have a percentage of innocent people who've been incarcerated for crimes they did not actually commit. And so asking them to show remorse for something that they didn't do, will read inauthentic if they genuinely didn't commit the crime, but also, holding against them avenues to appeal or avenues to, other mechanisms judicially that they may have pursued seems unfair and not a good standard to you. So I'm curious about your thoughts around that. Is the assumption that everyone who comes before you has done the crime?
No, I think we'd be naive to think that that doesn't exist, right? Systemic racism, what sentencing was 40 years, how cases happened, we'd be extremely naive. And it's been, in many occasions, people have served time that they didn't deserve. I'm very aware of that. When you talk about getting before the parole board and what we ask of folks that are before the board to admit to or not, particularly if they have litigation going on, that's certainly a consideration. I do believe that there's a process for folks to have a fair hearing and maybe hold themselves and explain to the board what they're going through.
So I'm curious if you've given thought to, and I understand until you join a board and start to do the work, it's hard to project what your thinking is going to be, lacking the experience of doing it. Having said that, if you could project forward, I'm curious under what circumstances you would be a no on granting parole or clemency for that matter, but let's focus on parole. Are there particular factors you would be looking for, the particular hard line, this person is not safe to go out and like, how would you assess and discern, or what would be the reasons that you would be a no?
I think when you're speaking about saying no, we need to consider all the factors that are before the board and set by statute. I also would consider input from victims, the nature of the crime, and where that client and what process they've gone through. Not everyone is eligible for parole, as we know. Not everyone that comes before the board, everyone is eligible for a hearing. So assuming that the person is appropriate, they have an opportunity. If I consider all the factors and I don't feel comfortable and I don't feel it meets the legal standard for release, I would say no. I don't have an issue with declining a parole if it's appropriate.
Can you explain that more? So especially thinking about not life hearings, where I think it's a different animal. Different word, that's not good. It's a different situation. With institutional level where the sentences are lesser and there's a point after which they're parole eligible, what would be a reason not to grant parole for someone in that circumstance?
I believe in the institutional level, House and DOC, our parole rates kind of speak for themselves. I would say not doing a hearing, but I would use the same factors. The criteria are there for all cases. I would love to see somebody come in and, you know, are they doing education? Are they working? Are they not? What support systems do they have? And if they don't, how are we holding that against them or not? It's really a balancing act. Again, as you know, the natures of the crime, victim input, there's a lot of process that goes into doing these hearings, whether they're before the board as a life or regular order hearing in an institution. We still have to apply the same factors. Public safety is a factor, as is the person's ability to show their rehabilitation within their settings, which is, I understand, can be very difficult to do.
No, I appreciate that. I'm gonna wrap, but I guess just as a thought, we did spend some time talking about the relationship between the parole board and DOC in terms of, you know, what the parole board is expecting of parole applicants in terms of participation in programming, participation in education, or other things towards rehabilitation. That sometimes is a disconnect between what actually is available in the facility in which the person has been incarcerated and what the board is expecting them to have availed themselves of. So, for instance, you know, not every facility, especially, I think things are evolving, but in the recent past, not every facility had restorative justice available, but the board really wanted to see it. There wasn't a lot of communication happening with those who are preparing for parole in terms of what is the board going to expect me to have done, and then they show up and they haven't done things that they weren't aware they should be doing. So I'm just curious about your thoughts about, given your background especially and the relationships you may already have as all being under the umbrella of EOPS, like what thoughts you might have about how to collaborate better and cross-communicate better in an interest of seeing rehabilitation and reentry actually become more successful.
Thank you for the question. It's a very valid question. It's been brought to our attention. We have, over the last year or more, under the prior administration, with the help of Prior Chair Hurley as well, built a really strong network. We meet quarterly or sooner with the DOC to discuss our relevant matters, particularly as they relate to housing and reentry. So I think that's evolved. I think we'll continue to do that. And I appreciate the work that we do with the DOC. The board is also working on having more information available to them. And as you know, in terms of the DOC, they now have tablets. And those tablets, and I believe Attorney Garland helped with that, do give clients information that they can reference. I understand it's not the same as having a conversation with somebody, but we do collaborate with the DOC, and we're aware, and the board is aware, and they've done an amazing job of trying to filter those prerequisites that you spoke about.
And the secondary element being classification, right? Where if there's a positive parole outcome that involves a step down, whether or not that's actually happening on the DOC side, and how much communication there is both ways. Is there two-way communication around if parole has had a recommendation, someone should step down to minimum and then be released after X days, whether or not that's happening and why if not?
There is an understanding that DOC has separate policies that relate to the classification of their clients. The board does work with, and in fact, our chief of transitional services is a prior DOC employee and has very good communication with those with those type of situations, so we can get back to the board where the board is inadvertently recommending step down, but the person has a high score and it doesn't work. There is communication to alleviate those circumstances where it does happen.
All right, I'm gonna leave it there. Thank you very much. Thank you very much.
Thank you.
Councilor Civil, do you have any questions for the nominee?
Sure. Thank you for being here today. Congratulations on your nomination. I know we were able to speak about, you know, your background and also some of the opposition that is against you. I know that it's important to have a balance, and it's important to make sure that both sides are being heard. But I know what was near and dear to me with the conversation that we had is, how do you look thoroughly to those who come to you during the parole board, and listen to their case. I know we spoke about my personal experience, my cousin who spent 27 years in jail for something he didn't commit and was exonerated in 2021. And went before the parole board multiple times and was denied. What would you do differently when having these types of cases where innocent people are in jail but looking to be released, but they're being denied multiple times?
I believe everyone has an opportunity to have a hearing before the parole board. Understanding the name, and first of all, I'm very sorry about your cousin's situation. Having the opportunity to be heard is it's a right. It's set in statute, right? It's your opportunity to have an opportunity to state your case. I would treat everyone as an individual and listen to every circumstance, understanding that I'm not saying that doesn't happen now. There are 7 board members with various backgrounds, but the opportunities to be heard and listened to are really key, and focusing not only on what you've mentioned here, both sides of the stories, and looking at what's relevant in that person's journey, both institutionally and in life, as a factor for release.
We did receive a couple of questions from people who would want us to ask you some of them. So I'm going to ask you, do you think training for parole board members is important? If so, what kind of training? And what kind of expertise training do you have in those areas?
So training for parole boards is extremely important. And we're actually, the parole board, I haven't been part of the parole board training, but I know through UMass Law and Psychiatry that is ongoing. They're training on right sizing conditions. They're training on what's relevant in terms of what conditions they're actually issuing and what impacts they have. And I'll give you a very brief example. The board with good intent will vote LTRP must complete. When you put that language in there, it can force a parole officer to detain you if you get held even for a small infraction. All of that data is being transpired back to the board, and the board's doing an amazing job of taking that into consideration when they vote. So the board is and it continues to train to those avenues, and those avenues are evidence-based practices are the best format that we have going forward.
And my other question for you is, what is your position in regards to board members conducting parole hearing remotely?
I think it's an avenue to, during COVID, as you know, the hearings were all, and it was efficient. I think that it will buy an opportunity. We're starting a pilot program in the House of Correction for remote hearings, understanding that not everybody can meet that. The board has 20 working days a month. And if you're talking about buying time to have the board do efficient cases and buy more time into the calendar to do more hearings, that is one. Technology has to be an advocate, I believe, in what we do. If it fits the person, if there's an objection or some need to do it in person, the board are very willing to go forward. I believe they do that now. But if we can buy the board, if a board member is driving 15 hours a week to go to one location versus they can be in Greenfield House of Correction, they can be in South Bay, they could be, it buys time for people to have more opportunity to be heard quicker. It also helps the client on the end.
And as we also spoke about victim services, I'm very victim driven. And, you know, I worked for the Suffolk County District Attorney's Office as a victim witness advocate, as well as being a legal advocate for a domestic violence shelter. How important is your role? How important is the role of a victim's supporters at the parole hearing?
I think it's very important. As you know, we have a victim service unit. We spoke briefly about Catherine Moran and the team that we have. Every office is assigned a victim witness coordinator. They, I believe, statistically issue over 17,000 notices a year. They attend every hearing at central office. There are resources that you spoke of that I wish, you know, I'd love to speak to you about that more to expand the services that we do have. I'm very proud of the work that the Victim Services Unit does. I recently attended the MOBA forum, and it was very impactful for me. It was one of I haven't been in a while to hear the stories of the impact that these victims have is very relevant to what we do.
Thank you, Councilor Civil. Councilor Dolan?
Thank you very much. Good to see you. Thank you so much for coming to meet with me. I really appreciated our discussion. As I said earlier, I've gotten more calls about your nomination than anyone I've had since I became a governor's council, which, to be fair, was not that long ago. It was just in January.
Any of them good?
Well, I want to talk about one of the ones that was very, very good. The folks I heard from were generally people that I have known and whose opinion I value and who I found credible, frankly, on both sides. One of the people I heard from was State Senator Jamie Eldridge. He's in my district. I've known and worked with him for years. I value his opinion tremendously. And he spoke very highly of you. And in fact, he is the co-chair of the Criminal Justice Reform Caucus, along with State Representative Mary Keefe from the House. And they sent us all a letter, and I just want to quote that they've come to know you as fair, principled, and dedicated public servant, and that they believe your appointment would further the progress the parole board has made in recent years, support a more just and effective criminal justice system, and enhance public safety by offering deserving individuals a second chance to reintegrate and contribute to their communities. So I appreciated all that, and I do want to address the positives, but I also want to address some of the concerns that I heard. As we've heard repeatedly, there's a lot of concern about your having law enforcement background, what that means. But you started in parole in 2012. Since then, have there been meaningful changes in your understanding of parole or the parole? What are they?
We have, as you know, criminal justice reform took place. We had a lot of policies such as fees that we imposed upon people that were terrible. Those are gone, not because of me, but because of legislation. We have a lot of reforms that have taken place that make sense. Giving people the opportunity to be in the community has always been a goal. Our officers, by the way, I'm very proud of the work that our officers do. The entire parole board, the people behind the scene are probably the most important people we have, from our cleaning person to every receptionist, transitional services. They are what makes this happen. And our parole officers transitions from you overdose and we're going to go to the hospital and arrest you, to calling a best psychiatric team and bringing you to the office and getting you treatment. They are driving people to treatment, Lynn Community Health Centers. They're getting up at 2 in the morning and taking you to a hospital. Our officers are 90%, 95% social work. They spend a lot of time with these clients, and I'll tell you how I know. Part of my job is to go to as many events as I can squeeze in. And I have people randomly coming up to me and saying, and naming my officer, say, that guy was great. He helped my client fill out a social security application. That's what we want. The law enforcement side of what we do is a public safety, but we're not police. I've said it out loud. That can frustrate some. I love working with the police. They keep us safe, but it's not what we do. Our mission is different, and we've evolved since 2012 until now. It has gotten, and our staff have gotten the message. Most clients statistically will have 3 or 4 violations before we do anything that's detrimental, not keeping them in the community. Understanding, yes, we still do detain people for public safety reasons or their own safety, but we have really evolved into an organization that has been more transparent. And by the way, criticism drives a lot of change, so I'm open to it. I'm not offended by any of it. The Criminal Justice Caucus is one of our biggest partners in helping us figure out, because they represent large groups of people. So I appreciate the question, but we have evolved dramatically. We don't pull people over in cars. We're not a police department per se. 95% of our work is having our staff, and by the way, we do about 80% of our work in the community, meaning we're going to you, stay in the community.
One of the things I really appreciated about our discussion was that there were a couple of times when you said, I don't know. And a lot of people can't say that. And one of the things was we were talking about alcohol use disorder and substance use disorder, which I'm glad that you've mentioned. As many know, my sister died of an alcohol use disorder. It's a very important topic to me. I know far too much about the cycles of recovery and relapse. And one of the things I think a lot of people struggle with is they understand how someone can become addicted, how someone could be addicted, but they don't understand why they can't get better. I mean, as you and I discussed, Matthew Perry spent $7 million of his own money in treatment and he still died from a substance use disorder. I've come to understand that it's a disability. So when you've got people who are on parole, who have that disability, what's your view of the appropriate response to chronic relapse, which we do tragically see sometimes?
We, again, just the parole officers have a lot of not enough resources, but we're partnering with, we have a good team at UMass that help us filter placements, substance use disorder. When folks are having graduated sanctions related to substance use disorder, this UMass team can help step in and say, hey, this person's had 2 substance use disorder tickets. How can we help? We're partnering with all the community advocacy groups to help us. It's not fair, and actually partnering with the clients that we serve to say, if you know, we can help you through this. We're delivering services to people in the community. Substance use disorder, we should expect that a percentage of our population will relapse. That is just a fact. We deal with that by providing opportunities to be in the community. We will take you to treatment. We will pick you up from a house of correction, particularly if you're in a bad neighborhood. If you're being released from the Suffolk House of Correction, that could be a tough play.
Here's what I want to know. Will you do it over and over and over and over and over and over and over?
We continue to do that. We continue to do that on an ongoing basis. There's a lot of value in having people in the community and be successful. I agree with you. We had a long conversation that's near and dear to my heart. I had a close, and I'll say it out loud, I had a close family member recently arrested and gone to court. And that touch point for me was super important because I was able to call, didn't work out like I thought it would, but having the police detain somebody, bring them to court, and take them to probation and offer them services is wonderful. And it sounds odd, right? Arrested, gone to court. I know the courts and I know the gear of helping people is important. So when that happened to my family member last month at 2 a.m, that touch point for me, I had a real different view because I've worked in the courts. I knew what it was like to be a probation officer and have to surrender somebody for drug use. It's very different. I've seen the evolution. I believe in the evolution.
Glad to hear that. Patty Guerin recommended a book. I'm going to recommend a book, and Counselor Jacobs and Counselor Civil touched on this topic. It's written by Daniel Medwed, who's the co-founder of the Innocence Network and a professor at Northeastern School of Law, and it's called Barred: Why the Innocent Can't Get Out of Prison. I want to ask you very directly, what's your view of whether someone must admit to the crime before they can be paroled? There are people who maintain their innocence for decades, and they're not innocent, but there are other people who do, and they are. And sometimes that means they can't get out of prison. What's your view?
That's a very difficult question.
It is.
It's a very difficult question. As you understand, being before the parole, and I haven't deliberated on a board, obviously. And I think those situations have arisen where clients come in and say, hey, I'm under appeal. I can't have that conversation. It's certainly a factor for us to consider. The statutory requirements are somewhat rigid in terms of what we have in place. We know it exists. The Harvard study says there's systemic racism in sentencing. We know all of those factors. I would take everything into account. And I don't have a direct answer for you. I haven't done it. I would say that's a very difficult question for me to answer. And to be quite frank with you, I do know it exists.
I appreciate that. Over time, we have found in Massachusetts that parole rates are going up, that more people are being paroled. Do you think that's positive? Is that something that you'd like to see continued if you become a member of the parole board?
I believe in paroling appropriate people. and public safety. Not everyone has a right to a hearing. I think if that person has been before the board in any type of hearing, they meet the standard. Absolutely. Paroling rates for us are around 70%, which is, I think, nationally pretty high for Massachusetts. I believe in parole, if it's appropriate. I like the numbers that I see, and what this board is doing.
I've recently learned that it's routine that petitioners are shackled during parole board hearings. I mean, during a trial, it's highly prejudicial if a defendant is sitting there in handcuffs. I would think it would have some impact. What's your view on shackling people during parole board hearings? I don't think it sounds good.
Correct. You've been to the parole board.
Not.
Oh, okay. So our setting is not the best setting, secure setting. We're in an open room. It's not like a courthouse. The inmates are brought in by the DOC. What's been brought to my attention more recently is extending. I would not agree to release somebody. Our room is in an open format. It becomes dangerous for the officers that are there that have the inmate. The public is there. If the inmate has an outburst, it's very hard to control someone in those situations. I do understand the logistics. Someone recently wrote into us and asked about having a client have extenders so that they can get their water and wipe their face. I believe in that. I would tell you that our setting is not a secure setting to the extent that someone could be released safely. We don't have like a holding dogs.
Something Patty Guerin mentioned, and something we talked about a little bit. You mentioned it as a special condition of parole, polygraphs. I mean, she's right. They're inadmissible in court. Why are we doing this? And do we need to continue to do this?
So we've been working on this behind the scenes. I agree with your view, by the way. We've gathered a lot of data. We've met with the Sex Offender Registry Board, and we're in the middle of evaluating this. What I will tell you this is that the board shouldn't be restricted for ordering one. My view is that if you order a polygraph, it should be ordered as determined by a licensed clinician versus standard for everybody, because that becomes very difficult to manage. So that is my view.
Conditions that are underused.
I believe the GPS conditions are overused, oddly enough. And I've been working towards that end. And I've formulated the data to be able to speak to the board and kind of say, hey, when you order this, you need to give a parole officer direction 60 days, 90 days versus PO discretion, because here's what's happened. So I don't, there's overuse of it.
Can you just clarify, when you say 60 to 90 days, you mean that the parole board would say
The only way
this person should be on a GPS for 60 days or 90 days?
what the data shows, and by the way, the only way a client is on a GPS is if the board orders it. So if the board does a generic vote with very good intent, which is GPS at parole officer's discretion. If you're a parole officer and a union member, you don't want to make that decision holistically all the time. So they will put a client on GPS and the person stays on for 6 months, but they've done very well. So what we've done is gather the data and been able to present to the board, not to tell them how to vote, but to say, this is the outcome of some of the votes that you're doing. The board has taken heed to that, and they're voting differently now. So they're setting a time frame, and then the person comes off. And now we have research providing reports to myself and the deputy chief. So there is a vote that's 6 months or 60 days. We get a report that says, hey, that's overdue, and the person's not off. And we'll go to the officer and say, what's happening here, right?
How much do you think parole officers should be empowered to determine conditions?
They should have input in determining conditions. They're supervising the client. The board sets the conditions, and our officers are able to ask the board through a change of vote and explain why a parole officer needs, a client needs a certain condition. They're really doing a lot of social work. They should have a point in that supervision strategy.
So what is your view of technical violations, meaning that someone violated condition of parole, but they didn't break the law? How should we respond to that?
Technical violations are very tricky. A technical violation could be you cut your bracelet off and absconded. That's, we've discussed that. That's a serious one. It could be that a victim is texting a parole officer and saying, I'm afraid of my client, but I'm not calling the police. So we err on the side of caution. We will go detain that client. I don't believe that technical violations, that if you're smoking marijuana, have done alcohol, that's a technical violation, and we're going to arrest you. And by the way, we don't. on those circumstances. So I do believe that violations have merit if they're appropriate, but I don't believe in the minor detention for minor offenses. You understand what I mean?
Should parole be terminated
Parole should be terminated.
more frequently?
I believe so, and to that end, I think the board is going towards that end with doing, I think, close to 19 hearings and 14 terminations. The prior chair did an amazing job of bringing those forward.
We talked earlier, you and I did, but also at this hearing today about Mattis hearings. And is your view of the SJC's view of the science, do you agree with what the SJC had to say about the science of brain development?
I do. Not being a scientist, I briefly looked at the factors that are there. I believe in the science. I believe it matters. It is another factor, along with many of the other factors that we have in deciding a case.
One of the things that makes Mattis hearings difficult, I would think, is that there may be loved ones, family members of the victim who expected person who's applying for parole to be incarcerated for the rest of their lives, and suddenly there's a very real possibility that they will be released. To what extent do you think the parole board, or would you consider the feelings of the families and loved ones of the victims?
I think 100%. That's a factor. It's really important. I can imagine that if your theory was that the person was in prison forever and they're released, that is shocking. That's very dramatic, and that's a consideration for the board to. I mean, victim input is probably one of the most important relevancies to what we do to listen to the community. So I believe it's a factor. I wouldn't venture to say that I know how to vote with all, again, I haven't sat on that panel. I'm going to need the help of everyone that's there to coach, get that model in, but I do believe in the science behind.
I asked you about what kinds of trainings you wanted to see parole officers receive. And I wrote down the answers. I can remind you what you said. You said de-escalation, impartiality, the signs of biases, and transitioning to more humane and supportive interventions. Can you tell us more about what that would look like?
So we're doing that now. We're doing fair and impartial policing, which is the science behind when every new recruit and every couple of years where we do a refresher comes in, it gives officers an opportunity to look at the science behind how we make decisions. De-escalation is part of the models that the MPTC uses now as well to engage clients, and coaching models. We're also working behind the scenes to have our clients, our staff, coach clients through the process through case management versus where's your pay stub, where's this, it becomes very informal. So building that relationship versus I'm here just enforcing everything is what we're, and by the way, again, I am biased towards the field services. I believe they do holistically good work in the community and they're very busy.
I have a couple more questions for you, but they're big ones. Tina Hurley.
Yes.
For many people is the gold standard.
Yes.
So everything I've seen and heard, she's the gold standard. To what extent will you follow that? In what ways would you differ?
I don't know that I can follow that. She has a very tenuous career. My goal would be to keep the same direction going. But keeping in mind, Tina came onto the board under some of the most difficult circumstances there were. 4 board members. She took over at a very perilous time and she kept it going. And not only did she keep it going, she expanded hearings. So I have a lot of respect for the work she's done. I hope to emulate some of it. I hope to continue towards the path of listening and engaging everyone in the process, including our staff. She was very good at engaging our staff, and that's something that I believe in as well.
My last question is, what's your vision for the parole board?
My vision is to continue to build evidence-based practices, to continue to train the board and our staff towards those ends, to use technology to our advantage to the best of our ability if it fits the client's needs. We know that can be helpful. To work with our partners and continue to evolve what our relationships are with all of the sheriff's organizations, the DOCs and vendors that we use. That is a vision that I think we're headed in. I think we can continue going in that direction. I would love to see the models that other organizations use in other states and practices to alleviate some of the work the board is doing. Whether that means legislative changes, right? Whether that means, that's a bigger picture. They talked here today about 9 board members. Can you divide and conquer the work and what makes a panel in order to be able to release somebody bigger than myself, but conversations I think that can be had.
Thank you.
Thank you.
Thank you very much, Counselor. We're gonna jump to Counselor Kennedy.
I'm stunned to learn that you're using polygraphs at all. I mean, the Supreme Judicial Court has said they're junk, that they don't belong in the courtrooms of the Commonwealth at all. Why are you using them if they're junk? It's junk science.
I obviously, these were in place, we're using them because it's a policy. It's a policy that we continue to review, and they're geared towards.
It didn't work. They're junk.
Agreed.
Why are you using them?
I don't personally use them.
Whoever is.
The policies that we have in place were there after what they call post-supervision containment treatment model. It's a national model by the American Polygraph Association, and I think originally
The American Polygraph Association is gonna say use them. That's how they're making their living.
So originally,
The Supreme Judicial Court has said junk science. They use those words. So why are we using junk science on people whose freedom is at stake? And saying, well, we just don't rely on that. It doesn't belong there at all.
I think the board is heading towards that direction and reviewing all of
So it's
that.
that direction should stop tomorrow. Period. Anyway, that's an aside. We spent a good hour and 20 minutes in my office and went through a lot of things.
Yes, sir.
And you answered a lot of my questions. I look at our view here as somewhat of a narrow one in terms of our job, what we're supposed to do. We're supposed to determine if you are qualified for this job. You may not be the person we want on the job, you may be, but our job as inside is the person sitting in front of us is qualified. And my friend Patty Guerin said something very powerful when she was asked the question, do you believe you're qualified? And her answer was yes. And I've seen her come in here over the last 15 years and say, no, I don't believe they're qualified. She's not afraid to say that. And that's pretty powerful because I think you're qualified. I'm not particularly concerned about the makeup of the board. I mean, you know, we've had a number of people come right out of DA's office and go become chairs of the parole board, and members of the parole board. And we've had times when nobody was getting out because of that. So sometimes that's a message that comes from the top office to the parole board. I think the message that the governor is sending is, you know, we want a parole board that is going to do the right thing and get people and let people out who deserve to get out. And put the right measures in place to ensure they don't come back, okay? And that was what I got from you. It came across. We talked about GPSs, the overuse of GPSs, which you apparently have strong feelings that they're definitely overused. We talked about a number of things. There's no question in my mind that you're qualified for this job. And based on that, I'm gonna vote for you. But I also talked to you about what my expectations were. And when you leave here, don't forget, you gotta come back someday,
So noted.
okay? Thank you.
Thank you.
Thank you, Counselor. I have to leave soon, so I'm gonna go out of order here, and Counselor Ianella has been gracious to offer to close the hearing after me. So I want to start by saying that I take a slightly different approach to my role as some of my colleagues, and I respect all of our approaches. I think it's what makes us a strong council. I do think that I consider the larger context of a situation when I'm offering my advice and consent, as the Constitution tells us that it's our role to do. And so when I first got on this council, we had not only a current but a historic, what I consider disproportionate representation of prosecutorial and law enforcement backgrounds. At a moment when criminal justice reform was happening, and I felt very strongly there was a need for a social worker. We got a social worker. I was very concerned about regional equity. it's my understanding, the most recent data I was able to obtain is that the board members are traveling. I know you dropped an hour figure. I saw that it was 16,000 miles a year, each board member, which is an incredible waste and inefficiency. And my view is that regional equity on the board creates less travel time if the schedules can coordinate as such. So I just want to offer that I do concern myself with the composition of the board, very much so. We heard some things that the legislature needs to address, expanding the board. Again, for me, we need regional designated seats on the board. That's my own thing. Thinking about creative ways to have a division of labor, whether it's clemency, House of Corrections, etc. You and I talked about that quite a bit. The legislature looking at whether we need the full board at every lifer hearing, because that creates efficiency challenges. Expanding the board would allow us to have a big enough group to be at those lifer hearings to make it fair. As far as I know, the board is not getting paid what statutorily it is supposed to be. And I wanted to ask you a question. There's a lot of legislation moving through the legislature right now, including about expanding the board. Every once in a while, bills get introduced. One bill that was brought to my attention would have a somewhat profound impact on parole. I'm just curious what your perspective on it is. The idea of a presumption of parole, that the burden shifts to the board to decide to deny parole, I suppose. I don't know if you've heard of that proposal. I'm curious what you would think about that kind of a change in the
I know
board's
that
approach.
happens in other states. And when that happens, it becomes more difficult, as I understand it, for populations to be released. So not seeing that, I would say there are many bills before I know the council expanding the board, and that is something I wouldn't really be in favor of. As I know it now, I'd have to look more to what that is without knowing it.
Okay, well, we can potentially follow up on that. You and I had a long conversation about conditions of release. I'm not going to reiterate it because it's been addressed, whether it's GPS, I mentioned AA to you. We talked about some other ways and the way that there's all these unintended consequences that end up playing out. We talked a lot about something that came up today, ensuring that our parole field officers do a tremendous job and a difficult job, that we're encouraging and recruiting folks who want to ensure that they're balancing that law enforcement with the social work aspect of the job. We talked a little bit about, I'm naming the things we talked about because they're important to me, and I want the public to know. The use of data. Some of the things we've talked about today, really, when finally there was movement on them, it was because we had the evidence and we had the data to back up these decisions. We talked about how, in my opinion, I won't put words in, this is not your perspective. In my opinion, we're at a very early stage of being effective at gathering and analyzing data. As far as, and what I mean is not that the work isn't good, that there's more of it that needs to be done. And an example I brought up to you was the House of Correction hearings, where there's a single board member. We have some special board members, retired judges who've come in to do that. The statistics are widely variable as far as the percentages going out. But it's great to have that data, but really that data, as you and I discussed and you acknowledged, I mean, in fact, you brought up, there's so many contingencies and specifics to each House of Correction, to each, you know, there's so many variables that we need to look at to be really educated on this data. And don't worry, I'm actually not going to have many questions for you because I'm getting through this. I think Tina Hurley, as you said, stepped into a very difficult situation. The board was down members. They were so far behind. They were down members well before she got there. And there was competing priorities. We have a large institution that's trying to shift with a lot of institutional impediments there. I'm really proud of the job she did. I'm really happy to see board member Coleman stepping in as acting chair. I heard it was referenced today that board member Coleman is indeed has applied to be a judge. And I personally hope that we do see him on the bench soon. Maybe at that time we can think about the roles that we need on the board, because I agree we need another clinical psychologist. Mary Keefe is one of my reps in Worcester. She's a leader of the Criminal Justice Caucus. Her and I are aligned on every criminal justice issue that could be imagined, and her support to me, and we had a couple conversations about you, means the world. The other two folks who reached out, including they sent us letters as well, but representative from ROCA, which is, what is that organization?
They're into youth development and supervision, helping people in the community, youthful offenders.
At-risk youth, youthful offenders, integration and getting them on the right path. It's an organization that I think does tremendous work. And then also UTEC. What is that organization?
Similar organization, at reentry work, we partner with them on various occasions, and we have clients in similar situations, not on parole with UTEC.
And folks from both organizations told me that working with you, they felt you were aligned with their values, and they felt that regardless of your background, they felt they'd have a partner in you on the board. That meant a whole lot to me too. And then you were able to share your insights and your understanding, and I was impressed that you had a good knowledge of this. This made me feel good of Emerson's EPI program and some other programs, similar programs that we discussed. I don't know how they feel about you. I haven't reached out to them specifically, but the fact that you were conversant in it made me feel good. And then finally, I'll just say retired Judge Luis Perez. He's someone I've worked very closely with to try to, because we both care about representation. And for me, working with court-involved youth, I think it's so important. And so it's not the reason to support a candidate, but it's an outstanding outcome that we're going to be continuing to diversify the representation on the board. So with that, I'm going to cut myself off. I'm already late for where I have to be next. Counselor Ionella is going to close the hearing.
Thank you yourself very much.
What's that?
Cut yourself off next week too.
Thank you, Counselor.
Good job, good job.
That's it.
Race is gonna fall apart now.
When this goes off the rails, it's not.
Good afternoon.
Good afternoon, Counselor.
Well, you understand, I think, already where I'm coming from.
Yes, sir.
And I heard Counselor Kenny refer or reference Patty Garland saying you're qualified. Yeah, I may agree with that too. But if you take 7 people and they're all applying for the job, you're qualified. But the question is, are you the right person? If 3 out of the 7, 45% of that board is law enforcement, that's where I'm struggling. And I think that's the impression I got from Patty Garland, but that's, I don't want to put words in her mouth. And if you look at your resume here, I mean, Counselor Kennedy, my good friend, you know, why are we calling this guy law enforcement? Well, municipal police program graduate, special state police officer annual training, internal FBI internal investigation certificate, your present job. To me, you're law enforcement. You're not going to convince me otherwise. 3 out of 7 members of the board. And you know what? People are not going to like what I'm about to say. The only way that board is ever going to change if this body stands up. If this body stands up, and it's tough, I have a great deal of admiration and respect for the administration. I'm a strong supporter of them. But if the parole board's going to change, if we're going to have more people with social science background, we have to take a stand. And sometimes it's difficult, but sometimes in the long run, it's the right thing to do. So that's where I'm coming from. Haven't made a decision, but you sort of have an idea where I'm coming from.
Yes, sir.
You know, and then I got this letter, I'm sure you've seen it from, no one's referred to it yet, I don't think, Brian Westerman.
Yes, sir.
You know who he is. And who is he?
He is a parole officer.
And I can give you a copy of the letter. Have you seen it or you heard
I
about
have
it?
not seen it. I just heard of it. I don't.
Okay, you heard about it. I mean, he talks about, I mean, I guess he's currently, I won't read it all, he's currently the president of the Coalition of Public Safety, which is the union representing the Mass Parole Officers Association. And he talks about. And none of these people are hearing your support. None of these people wrote a letter of support, and does make a good point. Like, why not? Why aren't these people publicly, whether in person or letters, supporting you? But it's not a great letter, put it that way. What type of assurances can you give this body? Because you may come back another day. Retribution. Very few people write letters. Even fewer people come in person to testify against someone. And why is that? Because they're afraid. They're afraid. Simple as that. No other way to put it. And if you get confirmed by this body and you get reappointed or look for another job, give me assurances that this guy Westerman, who I've never met or never spoke to, won't say that you did A, B, and C in retaliation for what he wrote. Give me an assurances that you won't go after this guy. I don't mean physically, you know what I mean.
Yes, sir. I have a lot of respect, first of all, for the union members. I was a union member right up until 2019 or 20 when I became in this position. I also respect Brian Westerman's position. He's very helpful to us. He does a lot of security. I have no gripe with any union member who opposes me in any fashion. I'm a professional. I'll continue to be so.
Thank you. When did you first apply for this job?
After the chair resigned.
Okay, I don't even know, when did Tina Hurley resign?
At the end of May.
So, end of May, like a month ago, 2 weeks ago?
My understanding, yeah. I don't know her exact.
So wait.
She retired on May 27th.
May 27th, and you applied after that. Today's June 18th, so.
You're asking me, when did I apply?
Yes. I thought you said after the chair resigned.
I understood she resigned.
That's what I'm saying. When did, you said she resigned May 27th?
I don't have the dates of when.
Give or take, the end of May.
I don't have the dates of.
Yes.
She gave 30 days notice.
Yeah, so
30 more days.
sometime in May, I don't know she left in May.
Applied after she resigned. Is that right, or
I
before?
believe so. I don't know her dates. I know that her last day was May.
What made you, was there an opening when you applied?
There was an opening,
And who was the opener?
her opening,
I can't hear.
her opening.
Well, that's what I'm saying. You wouldn't have applied if she didn't resign.
Correct. She sent out a notice.
Yes, you could have, yeah.
She sent out a notice agency-wide.
Good. Okay. And my understanding is she wanted to be reappointed. Is that your understanding?
I've never had those conversations with the former chair.
I've never spoken to her in years, just to let you know that.
Yeah,
But my understanding is she wanted to be reappointed.
Okay.
And I'm hearing today from almost everybody, she was the gold standard. She was pretty damn good. I know you're hearing yourself. What's your opinion that this person, Tina Hurley, did an outstanding job? She was the gold standard. You listen to everyone, no one could have done better. What's your reaction? The fact that she's no longer at the board.
I agree that she did a great job in terms of her not being at the board and what decision she made to resign. I have no view on that. I don't have, I've never spoken to the chair about why she resigned. I respect the work that she did while she was here and her long tenure at the parole board.
Fair enough. Do you have an opinion as to what the number is? That it's too many law enforcement individuals on the parole board. Is 7 out of 7 too much? Is 5 out of 7? What's your opinion? They may all be qualified, but put together, there's a problem. What's your number? What would you say?
I don't have a number. I think you take the person on the quality. I do believe that we need a doctor. We have a clinician. I also believe that my background just lends itself to different avenues in terms of what I bring to the board. I don't oppose your view or Attorney Garen's view that more clinicians are readily needed on the board.
Based upon what you're saying is 6 out of 7 would be fine. I mean, they're qualified and, you know, we know we need someone with a social science background. I'm pretty sure we heard that today, Dr. Bonner. But, you know, take everyone, you know, bring their qualifications and they're all like you. We could have 6 other people and I think that would be horrific, awful. But I'm not getting that from you. It's nothing to do with you, by the way. But I think 6 other people with your background, way too many on the parole board. You don't agree with that?
I think it could be very detrimental. I think that was brought up here by other counselors in terms of what the makeup of the board is and what effect that has on paroling rates. So I agree that people with varied backgrounds, including clinicians, Dr. Bonner should be on the board. I do.
We got it. I'm not gonna hop on this, but the limit, I think would you say is 3 out of 7? 4 out of 7? I mean, what's the limit? If you had to give a number, law enforcement people on the board, I think myself, 2 is the number, okay? Would you say, you're obviously gonna be number 3, would you say 3 is the limit?
I would say that the limit is determined by the person's character and their work.
Okay, so you don't have a number on that, fair enough.
I don't.
Okay.
I believe in clinicians. I believe we actually work.
Got it.
with clinicians.
I believe in all those people too, but we differ on that. You know, we clinicians, people with social science, but if we had 6 out of 7, that's okay. They're good people. They got a good background. I think it's too many myself. I don't have any more questions, but at the end of the day, again, like I said, to me is 3 out of 7, almost 45% of the parole board. Is it who have law enforcement backgrounds? Is that too much? And I'm here every week. And when we have a nominee to be a judge, and it's a prosecutor, I always ask the question, you know, once a prosecutor, always a prosecutor. When we have 3 out of 7 law enforcement people, are those inmates gonna get a fair shake? That's what it's all about. I'm not saying release everybody. That's not what I'm saying. Are they gonna get a fair shake? Everyone says Tina Hurley. Well, Tina Hurley was at somewhere I heard at 65%. Another parole chairman was at 35%. There's a big disparity. Okay, so that's where I'm coming from. You know, I wish you well, but you know, again, it's I'm struggling with that.
Thank you, Counselor. I appreciate it.
No more questions. I don't have any. Does anyone else? Well, thank you very much, everyone. That will conclude the hearing.